6. Submission is made on behalf of petitioner that he has some personal difficulty, but it's for him after 1 week.
Chief, I beg to mention item number 49. Here in this matter, I am for the respondent, but the conducting counsel, Ms. R.D. Mazumdar, is unwell. I tried to contact the address.
Wait for the matter to be called up. 2016 matters.
Lordship, but she is not well.
You wait until the matter is called up. Yes. Yes. Instructions.
Lots of fun this week. Become. I'm so sorry. But sadly, the instructions are not very favorable towards the petitioner. If your lordship will kindly take up page 3 of the page 3 of the bunch, which are just at least 8 years and above.
No, class 3 is 11 to 14.
No, your lordship. No. That you're also seeing you're also seeing the first number. You're also seeing 4, 3, 3, and the way that it has been broken up, your lordships. Secondary, middle, your lordship will see preparatory on the right hand side, preparatory. So that is classes 3 to 5, ages 8 to 11. Lordship have got it. So the NEP envisages that the age of a child has to be 8 years if the child is seeking admission in class 3. The same is also reiterated in page 4, where if you also see clause 4.1, this is where they have talked about how the entire NEP will work. And the third last line of this 4.1, the preparatory stage is grades 3 to 5, covering ages 8 to 11. The third last line of clause 4.1. Now, considering the fact that we are a specified categories tool under the RTE, your lordships, we are required to comply with the NEP. In terms of that, we have issued our own admission guidelines, and the admission guidelines very clearly envisage which he has annexed.
What is the guideline for transfer in the mid-academic session?
Lordships, perhaps what happens is that this child has not come from a Kendriya Vidyalaya, lordships. The Kendriya Vidyalaya at the very initial level, at class 1 itself, selects and chooses these age-appropriate students as of now. So if a child has to be 6 plus to take admission into class 1, that is the policy of KVS. Exactly a similar matter in respect of class 1 was the subject matter of a dispute before the Honorable Delhi High Court. I have this, you also find that at page 7.
We'll come to the judgment.
Yes.
Plus, explain to us
yes,
that under no circumstances can there be a transfer in.
There can definitely. In fact, we have already at page 2, your lordships, we have already offered him an admission in class 2. He has refused. Age appropriate wise, we have offered him admission in class 2, which the father has refused to take. Now, where is our fault? Our policy is very clearly saying 6 plus for class 1, 8 plus for class 3. And that is uniformly applied.
How old is the child?
He is just short of 8 years old.
Above 8 years old.
Huh?
On 16th of April, his birthday is on 16th of April, my lord.
Yeah, the cutoff date is 31st of March. The cutoff date as per the NEP again is
So
the
he's
31st
above or
of
below 8?
He's below 8. The minimum age criteria. The NEP gives us a flexibility, and also the KVS guidelines give us flexibility in the maximum age limit.
Where
So if the child is slightly over
where have you
age,
stated the age of the child?
my
Which
lord,
paragraph?
yes, my lord, this one. My lord, annexure 4, my lord, page number 20, my lord. This is the birth certificate, my lord.
We are asking you the age as on date. Why are you showing us the birth certificate?
So I apologize, my lord. My lord, at this point in time, he's 8 years and 3
Where
months
have you
old.
stated in the pleadings? On the date of filing, how old is he?
My lord, I have written the approximate age, my lord, at that point.
Where have you written?
My lord, in the cost item, my lord. I'm so sorry, I apologize. 8 years. In the cost item, I've
You
mentioned
have
about
written aged above 8 years.
yes, my lord. At this point in time, he's above 8 years old, my lord, because his birthday was on 16th of April, my lord. And now it is the month of August, so he's already 8 years and 2 months old at the.
And he
at this
was
point in time.
seeking admission for which month?
My lord, he was seeking admission in class 3, my lord. At that point of time, the age
At
eligible.
what point in time?
My
Which
lord,
month?
in the month of June, my lord.
6th of June. If he's not 8 years old, then how is he 8 years
No,
old?
no, my lord. He was above 8 years old at that point of time. But as per the admission criteria, the cutoff date was prescribed as 1st of April, my lord. As per that, he was not 8 years old.
He was not seeking admission in April.
He was seeking admission in the month of
he
June,
was
my lord.
seeking admission in the month of June.
Right.
The cutoff date for checking the child's age is 31st of March of every year. He has not come from a Kendriya Vidyalaya Sangathan, Your Lordship. He has come from a public school. They did not check his age. They may not have implemented the guidelines of NEP in that public school as of now. But we are bound by our own policy, and our policy very categorically
Where is your
states.
policy?
Lordship, he has not annexed it. I have one copy of it. I'm just going to mark the relevant portion, and it's annexed to the page 23. Lordships, kindly find it. Annex 7.
What is so difficult with the admission of the
Lordship,
child?
the
vis-a-vis
difficulty.
your policy.
Lordship, the thing is that we have offered him in class 2. He's refusing to take it.
He's 8 years plus. As on date.
As on 31st of March, he was not.
Today he did not seek admission in March or
Lordship,
April.
the point remains that the child has to be age appropriate as per the class. When the child is coming to
Madam,
us,
he did not apply. He's not a regular student who's seeking admission in a school at the beginning of the semester
But
or the academic year.
the minimum
He's seeking admission midterm.
Does that mean that the age criteria will not be applied to him?
Certainly, but
So
on the
as on
date
31st
when
of
he's
March,
seeking admission, you'll have to find out what age criteria he
so
belongs to.
therefore, Your Lordship, the cutoff date as per KVS guidelines is
So
31st
back
of
to
March.
cutoff date.
And Lordships,
Either you say midterm is not possible under any circumstances.
that is not our
Then-
case at all, Your
Then
Lordships. The fact remains that the child has to be age commensurate on the
provided
day
he seeks
and-
admission in March. He did not seek admission then.
because he is not coming from Kendriya Vidyalaya Sangathan. Your
Whatever
Lordship.
it is.
That is what I'm saying. That is what my humble submission is before Your
So
Lordship. The
therefore
rest
you
will
are
be Your
saying that
Lordship.
unless you are a KB student,
Lordship.
no midterm is possible.
Because when at the initial level and in class 1, we
You are going
always
back
check
to
the
initial
age of the
level.
child.
We are not on that. We are,
Lordship.
see, nobody comes for midterm changes for pleasure. Either you are
Lordship,
kicked
I
out
wish
of
we
the
could have
school,
accommodated the child. The thing is-
either you were kicked out of the school, or these are the cases where a parent or parents are transferred. etc. Now, on a date when the child is before the school, you are going back 3 months to say that the child does not fulfill the age. Maybe, but he or she did not seek admission in March.
Because Lordship, the minimum age criteria, there is no relaxation. There's relaxation
age-
in the
Minimum
Lordship,
age
kindly look at the
criteria you
board
will hold
policy.
on
Lordship.
only and only on the date when you advertise and you give a cutoff date. This is not one
It
of
is
those
there.
cases.
It is there in
It
the
is
written
not
petition
one of
itself,
those
Your
cases.
Lordship.
Why are you insisting on that? This is the case where the child has come for admission in midterm. You say
Yes,
that midterm
from
is not
another
possible.
public school. He has not come from Kendriya
Then
Vidyalaya
you say
Sangathan, Your
that
Lordship.
Kendriya Vidyalaya doesn't allow midterm transfer.
Within the Sangathan, of course we do, because we always initially at the initial level and class 1 itself, we
You
check
are representing KV
KV
only.
only.
And who's representing the school?
No, I am representing the school as well, Your Lordships. ONGC is a project school. So it is run by Kendriya Vidyalaya, but the entire financial aspect of it is taken care of by ONGC. So I am representing the one number
So-
क्या है? 2 to 4 your lordships. 2, 3 and 4, yes.
The whole purpose of these rules is to ensure that the child gets proper education.
Lordships, the NEP is
You
very
are
specific. They have
NEP
changed
what
the
is the
pedagogy.
purpose of NEP?
Lordships, it
What
is
is the
not,
purpose of
it is
NEP?
only my submission before your lordship. Your lordship kindly consider it and then pass appropriate orders as per your lordship's inclination.
No, we
The-
can pass
the-
appropriate orders
The
anytime.
NEP is very
We
clear,
can pass appropriate orders
We are bound by
anytime.
the
We
NEP.
are only asking you
lordships.
to,
And therefore I'm
to
placing before
examine
your
a
lordship.
case which is not an ordinary case of a child coming for an admission who does not fulfill the age criteria.
That is why
Then-
we had to
then
check
the
it out, because
petitioner
he's
would
not
not have
coming
had a
from a
case.
Kendra Vidyalaya.
Here is a case where they are asking for midterm. Either you say
Yes.
that sorry, no midterm is available. These are our guidelines.
Yes, your lordships. Within
Then-
Kendra Vidyalaya Sangathan,
Then
midterm
if
is
we are
definitely
allowing
available.
midterm,
He is not from a Kendra Vidyalaya. He comes from a public
how
school.
does it matter if you are allowing
It was
midterm?
not checked at the relevant point of time. We have, your lordships, my only submission to your lordships is that our policy is very clear. Your lordship will just take up page 27 for a moment. Just for a moment.
Page 27, no?
Of the writ petition.
Yes.
Eligible age for admission, your lordships. Class 1, 2, 3. Your lordships will find class 3. Now, your lordship will see the column minimum or maximum age as on 31st March of the year in which admission is sought. Now, it is 8 years, but less than 10 years of age. So, for the maximum age, there is flexibility of almost 2 years.
As
The
on,
minimum age,
as on 31st
31st
March.
of March. He was not 8 years of old.
Exactly. He
Ex-
did not seek admission on 31st March or 1st April.
But, your lordship, the fact remains that he is seeking admission for class 3.
Right? He completes 8 years now.
Now, today. But
Yes.
as on 31st of March, he was not.
He was not.
So, therefore,
He's not.
and this
he's not
exact same
coming
issue,
for a regular admission. We are repeating that.
lordships.
Had it been a
Your
case of
lordship can
regular
take
admission.
that view, that definitely can take that view. But the fact remains, this is how we operate. These are the facts that Kendriya Vidyalaya is relying on. They have a policy which he has not challenged. The NEP has given
Why should
his
he challenge
guidelines.
the policy? Why is the policy required to be challenged?
It may
Is
not
the
be,
policy so rigid?
but he's
Is the
himself.
policy so rigid
If
that
he's
you
coming
cannot accept?
us, lordships, if he's coming to us for admission, he has to abide by our guidelines. That is all.
Exactly.
That is the only thing that I can submit before your lordships.
You are an educational institution. The sole purpose is to educate child.
Lordships bound by the RTE and bound by the NEP,
Then
and therefore,
why are you finding fault?
no, I am not trying to
If
find
you
fault.
can say that, all
This
right,
is-
we need
It will
to take
become
a
a
test.
precedent. The
We need to take a test and the person does not satisfy the
Lordship,
result.
there is a
We'll accept it.
that is exactly what I was trying to tell your lordship, that there is a Delhi High Court judgment which has been approved by the Supreme Court, where the minimum age criteria has not been
When is
relaxed.
that High Court
It's
judgment?
it's at page number 7 of this bunch. Your lordship. The effective portion, exactly the same debate was there before the Honorable Delhi High Court. The only difference was that here was a case of class 1 and the children were not yet 6. They were 5.5 or something like that, but not yet 6, which is what the NEP envisages. If I may take your lordships to paragraph 22 at page 16 of this bunch.
This is the case of regular admission.
Regular, yes,
How is it relevant for the purposes of this proceeding?
because the minimum age criteria was being considered.
You stick on the
Because-
minimum age criteria. We are asking you this minimum age criteria on the date he sought admission. Does it
Your
apply to
lordship
him?
can definitely take that. Like I said, we have no harm. We have no qualms in giving him admission, your lordships. We have offered him admission in class 2, age appropriate. He has refused
What age appropriate?
because the
Why should he go back to class 2 when he is a child of class 3?
because the maximum age, there's a relaxation, your lordships. The minimum age there is
That is what is
as of
surprising.
30.
That is
why
what is
he's seeking
surprising
admission
and
to
disturbing.
Lordships, then
That the Kendriya Vidyalaya Sangathan is a stickler for norms, overlooking the needs of a child.
that is not
You are
that is not the
exactly,
case.
you are,
That, your
you are,
lordship can
you are
not take
giving
that
him an
view.
offer to go back
This is-
to class 2 because he doesn't satisfy your
Lordship,
guidelines.
because it would now become a precedent. If your lordships holds that
Of
we are
course.
required to give him admission, then it becomes a precedent for us. Then we have to.
It is a.
Then it
You
is against
take a
the any
policy.
clear options.
You take a policy that unless you are a KV student, we are not giving you midterm. Take a policy.
That is
What
not
stops you?
Lordship, that is not our policy at all.
Then-
We do take midterm, but we
then-
are bound by the criteria laid down in our own admission guidelines.
Then this measure of criteria is incorrect. I'm sorry to say. You can't
Then your Lordship-
insist on the
then your
criteria
Lordship-
for midterm,
Lordship,
which is applicable to fresh admissions. You can't do that. Why will you do that?
Lordship,
On a day when the child is approached before the court, before the school, satisfies the age.
Lordship, the cutoff date for any admission in any class.
Exactly. That rules out midterm. Midterms are an exception.
In my respectful
You
submission,
take
Your Lordship, that
you take your instructions, you get policies to say no midterm. We'll accept it.
no, that is not.
You say
that
we'll
is not
give you
the case.
midterm only
No,
if you are a
no.
KV student.
No, Your Lordship.
We'll accept it.
We
You
do
take your
accept
you take a
midterm, we
policy
accept
decision
projects
that even if
as
it
well.
is for midterm, you'll have to sit for an examination and qualify. You
That-
accept it.
The RTE doesn't permit that.
Doesn't permit, so don't insist on it.
We are not asking
You show us
for
that
an
RTE
examination.
permits you to measure the cutoff date for fresh admissions in cases of midterm.
Lordship, that's the
You are
education. That is
you are
our policy.
essentially asking that today the child is ineligible because in March he was below the age criteria,
Yes.
right?
Yes.
But in March he was
Because
not below the
31st
school.
of March is the
He did
cutoff
not
date for
apply
admission
for
to
he
any
did
class.
not apply for fresh admissions. Did not.
Lordship, that's again, I reiterate, Your Lordship. The fact
Alright,
remains
but-
that there is
Counsel to the parties, they should please return. This matter had earlier come 3/8/26 when MSR Bora and the CGC requested to appear and obtain instruction AVS panel. On the following date, 10/8/2026, MSR Chaudhary appeared before the court as standing counsel for AVS arrest of petitioner is aggrieved by the refusal to admit the child. The petitioner, Kendriya Vidyalaya Sangathan School, which is run by the ONGC. So, the father of the petitioner is transferred to
My lord, Sivsagar, my lord.
from
Sir,
Mumbai.
from
Mumbai to Sibsagar, and therefore the child had to travel with the parents of the father, and the child had already completed class 2 by and is now sought admission in class 3 in the NGC school is run by the KVS. Child has been denied admission on the ground that on 31st March 2026, the child did not complete 8 years. There is no dispute that as on date, the child has completed 8 years. Child is a few months above 8 years. Considering the above, the respondent were permitted to obtain instructions whether to be R.S. Chaudhary is given to the court with the instructions to submit that under the NEP 2020, the age criteria specified for class 3 is between the ages group of 8 to 11. So, therefore, the age criteria specified has to be satisfied by any student who intends to undertake admission. The council therefore submits that this age criteria has to be decided as on 31st March. Therefore, as on 31st March, this petitioner did not complete 8 years. The admission sought for in the month of June 2026 was declined, as according to the KVS and the school, it's necessary that the intending student, that the student intending to undertake admission KVS must be within the age group of 3 to 5 years, and which age they must satisfy is on 31st of March of the academic year.
Lordship, you have written the age group as 8 to 11 for class 3.
8 to 11
For
class
class
3. 8 to 11 class 3, which they must satisfy 31st March. From the pleadings available before the court, and from the submissions made, it seems that the petitioner did not seek regular admission at the beginning of the academic year. Rather, the petitioner is seeking midterm admission in so-and-so school, as he is required to be shifted out of his earlier school in Mumbai because his father has been transferred to Sibsagar, because his father was an employee of the All India Services
Yes, my lord.
and transferred to Mumbai. So, queries made by the court, the learned counsel for the respondent submits that there is no policy that midterm admission are not accepted by the school. End of legal, that midterm admissions are accepted only and only if the student had studied or undertaken education in any KBS school. School in which the child had undergone education by is not a KBS school. So, there is also no instructions by the respondents as to whether any test.
No test.
The
Absolutely clear, no test.
Submits, there is no test required for the student to undergo before seeking admission. So, the only criteria for which needs to be fulfilled is the age criteria, which the child will have to complete by 31st March 2026. So, counsel for the school is pressed into service. The judgment rendered by the single bench of the Delhi High Court. Wherein the Delhi High Court rejected the similar claims made by a child therein who was overaged at the time of admission.
Underage.
Huh?
Underage. The child was not yet 6. The first line of the judgment. First line. He was not yet
underage.
6. Underage.
Underage from 31
Which is the
2020. This order, this judgment ultimately dismissed the writ petition. Stop an appeal filed before the apex court by order dated 25/4/2022. The apex court dismissed the SLP and held the findings of the single bench. So, having perused the said judgment, we see that the judgment, the facts involved in the case pertain to a student who was seeking admission in a particular class in class 1, regular admission in class 1. However, the student not having fulfilled the age criteria as on 31/3/2022, the admission was rejected. So, in the facts of the present proceedings, the student is not seeking regular admission as on 1st of April 2026, and therefore the age criteria is required to be satisfied as per cutoff date of 31/3/2026. So, this is the case. This is an exception to the normal rule. Transfer in midterm. So, the learned counsel for the respondent being instructions having submitted that there is no restraint for midterm transfers, or that midterm transfers are not accepted unless the child had earlier studied in a KVS school. Which the child has been child's transfer has been admission has been rejected is because it does not satisfy the age criteria of 8 to 11. 6, sorry, what is that? What is the age criteria?
8 years.
8 to 11.
Then back to classes 3 to 5 years.
Therefore, the classes 3 to 5. And therefore, the admission, as on 31/3/2026, the admission rejected. However, in dispute that the petitioner has completed the minimum age limit prescribed as on date, even on the date when the petitioner had approached the school for midterm admission, which is in June 2026. Under such circumstances, considering the issues involved, that is issue, and it will 3 weeks. Respondents may complete their instructions and file necessary affidavit. Meanwhile, until further orders, the petitioner, having completed the minimum age limit as specified in the guidelines, shall not be denied the admission on the ground. Stop this order, however, subject to further order passed by the court. If you want 2 weeks, we can make it 2 weeks. 2 weeks, 2 weeks. Release this matter again after.
Obliged, my lord.
Weeks 28th.
28, yes, sir. Diploma.
Yes.
Recall, my lord, in this case, I have not said the leading case, but the case, the one, and in the first serial, my lord, that was already argued by Mr. Chaudhary. And my lord, we are also similarly situated, except there was the prayer, there is a slight difference in the sense that the seniority is common to my lord. Both these cases, my lord, that case and also this case. We are appointed in the year 2012 as that teachers. We carry the requisite qualification.
Your claim is that you are working on contractual appointments.
Contractual appointment.
Now there is a proposal to give you regularization, treat your services or make it regularized.
That came our way, but we declined, man. Because that would have from a prospective date. That is the reason, man. And we lose this seniority
You are
of more than a
challenging
decade.
this.
Madam.
What is your grievance before the court?
But our grievance is that you regularize us with retrospective effect from the date of our appointment, 2012. When we say the manner in which our appointments were given is not envisaged under the Right to Education Act, man, or under the rules, man. It doesn't say, and it
They
also
are willing to give you regularization, government.
my lord, regularization with retrospective effect.
No. As far as the government is concerned, they are accepting your prayer for regularization. But from a
Prospective date, man.
your services rendered earlier are not taken into it.
Exactly. And this period of seniority would also come, my lord, in our further benefits, service benefits, man. Our promotion, my lord, we can get advancements up to the post of headmaster in
One pension,
P1 pension, man.
1969. That's the only criteria. Yes. So then everything, just the outer government.
Here is again
You want pension from 1969, not 2005.
from the code. Yes, madam, pension code as per the pension.
Therefore, your services are.
The argument that was offered on that date was quite exhaustive and I cannot get away from it because we are identically situated. But I'd just like to, my lord, refresh your lordship's members. And be short. I appear in 3 cases, my lord. Item number 14, 15, and 22. My lord, 14 is in respect of lower primary teachers. And also 15 lower primary teachers, my lord. But item 22, my lord, it pertains to upper primary, my lord. It is 6 to 8. Lower primary, my lord, as they are, my lord, they are +1 to +5. And upper primary, my lord, 6 to 8. And item 22 in the list, that is in respect of upper primary teachers, school teachers. My lord, as was already submitted, my lord, we came through, my lord, we were appointed after a selection in a duly held selection process in 2012. Initially, though, we were given a lump sum amount, my lord, of rupees 14,000 per month. But, my lord, by 2013, my lord, we were given the scale. Pay and great pay and all, my lord. And we are also given benefits up to, my lord, the recommendation of the 7th Pay Commission. So on that, my lord, no issue. But only thing, my lord, not only were we appointed as contractual teachers, but we were also made to sign some agreements. Even now, my lord, there is an agreement, my lord, that is in subsistence still.
These are not challenged now.
My
I
lord.
mean, these are not challenged then.
But we did challenge them, the agreement.
Then what happened?
Nothing has that just come for hearing. Whether that agreement is
When were
admissible,
you appointed?
my lord,
When were you appointed?
in the year 2012.
2012. Pursuant to some
And,
what agreements.
no, pursuant to some advertisement.
You were selected. Where are you? Appointment order. You are appearing in item number 54.
But this is 14, my lord.
Huh?
14.
Sorry. 14.
Yes.
When were you appointed?
My lord, that particular advertisement appears in Annexure 1, page 239.
Nine.
Yes. This was the consolidated advertisement for appointment of lower primary and UP teachers, upper primary teachers.
So it was advertise that this post will be on contractual basis.
Contractual. Well, except,
Then
but the law doesn't say, man, the statute under which, man, you were appointed, man, it doesn't provide for contractual. That is the,
but you accepted it
my lord,
in 2012.
we were beggars, my lord. And they
Okay.
sent us on, my lord, training at their cost, man. And we all successfully completed it, that DLED course. Now, my lord, Annexure 2 is the, my lord, order by which we were engaged in service, man. Pursuance of the provisions of the Right to Education Act. Your lordship will kindly see name of the statute will figure everywhere, man. And as per the advertisement mentioned below, the following candidate is selected by Ahom Horbahikha Obhijan Mission Assam for engagement as assistant teacher in lower primary school in Nagaon district of Assam, purely on contractual basis and terminable at any time without notice, and assigning any reason there for a fixed amount of 14,000 per month, including leave and other allowances as per state government norms from time to time. However, instead of GPF, the contractual teacher will be entitled for contributory provident fund. The selected candidates will have to first report to the district mission coordinator at the concerned district mission office, SSA, and submit joining report within 10 days of receipt of this order. The posting order of the candidate against school concerned will be issued separately. A candidate once posted cannot apply for transfer to urban area. The selected candidate will have to attend induction training on the date and the venue specified by the district administration. So, my lord, the purpose was to, my lord, strengthen the network at the rural, my lord, in the rural and interior areas where we were posted. That is all right, my lord. Your lordship will kindly come to the bottom. The selected candidate has to sign and execute an agreement with the concerned school managing committee initially for a period of 5 years. Within 5 days from the issue of the posting order, his engagement will be with effect from the date of the joining at district mission office SSA. The selected candidates who doesn't have the professional qualification will have to compulsorily complete 2-year diploma in elementary education within 31st March 2015 as per the guidelines of NCT. Further, those candidates, and then it doesn't pertain to us. So we were sent on deputation on for this 2-year diploma in elementary education, at their cost. We had to pay just a registration fee of 5,000 and we completed it. And thereafter, we were given scale.
Yes.
Now, next page is the agreement. It is called Agreement Form for Engagement of Assistant Teacher under SSA Assam. This was for a period of 5 years, madam. My instruction was that it was discontinued, madam, after 2017. And one-time agreement was signed for the entire period till, the date of superannuation, that is 60 years. From in 2020, that agreement is subsisting. The next page 243, at clause 5, it provides for the party will be entitled, second para from top. Party will be entitled to get leave as per the state government leave rules. The casual leave will be granted by the SNC, the school managing committee, and other leave benefits will be granted by the concerned distribution coordinator. And skipping man. Then by the document at Annexure 4, which is dated 29/5, page 245. We were made entitled to, medical allowance and DNS allowance. Medical allowance at the rate of rupees 600 per month. DNS allowance, 80%. And then the scale, on the basis of which that DA and MA will be calculated is given. Page 246. The Lordship will see the pay band at serial 1 for upper primary maths and science teachers 5200 so. Upper primary social science 5200 and lower primary is 520020. This is
How are you disadvantaged
now, my lord.
now if government
My lord, it will always have that aura of contractual appointment around us and this agreement, my lord.
No, no.
My lord, if the agreement is,
listen to the
my
court.
lord.
What we want to say is that let us say for today you were regularized. You will be bound by the new contributory pension scheme. Are you agreeable to that?
New pension scheme. Pension scheme, my lord, will come only if we, my lord, the issue is not only pension, my lord, the seniority from the regularization with effect from a retrospective date from the year 2012 or 13. My
So
lord.
then you see, there are many issues which you will have to flesh it out. Number one, we have a valid contract. Sign the contract.
My
What
lord,
will be the value of the contract?
I'll come to that, my lord. I'll come to the citations that I'm going to place, whereby
No,
these are-
they rely on
this practice
judgments
is,
to say that these are
and
unconscionable.
not only that, my lord, nowhere in that Right to Education Act it is provided for.
Then the very engagement of teachers as contractual itself is contrary to right to
Yes,
education.
it is unlawful, my lord. The contract act doesn't allow it. It is
Then you would accepted that for all these years
my lord,
There was
that
not-
is one way of looking at it.
without any demand.
No, not
there was no
we have been
challenge.
representing since long, my from day one, my lord.
Representation
Countless
is not
number
there.
of discussions have taken place between the government and the associations or the group of teachers.
That's okay, but you've accepted it. At least within the first tenure of 5 years, there was a challenge made that no, you can't appoint us like that. Whatever grounds you make.
Well, in support of that, my lord, I would like to, my lord, place the apex court pronouncements. I'll come to that later. I'm just placing the documents. Then, my lord, the payment 2 and also at the serial 3, my lord, grade pay. And then, my lord, that is worked out, my lord, the deduction and all that. Professional tax, CPF, etc. And by these document, my lord, we were also made entitled to house rent allowance. Page 247. Now, your also will kindly see, my lord. With the same qualification, my lord, there is another set of teachers in the regular scale and regularly appointed. That is what they say, and that is called, my lord, state pool. We are equally footed, my lord, when we are appointed. Now, the concerned Department of Government of India, my lord, which introduced this scheme, my lord, SSA. Earlier, my lord, used to be called Sarva Shiksha, now it is called Samagra Shiksha. Here, my lord, one document I have given, my lord, this is Annexure 6, page 251. This is the minutes of the 213th PAB meeting held on 1st May 2014 for approval of annual work plan and budget, my lord. This connection, my lord. Your lordship comes to page. My lord, why we were discriminated, why were we not, my lord, put at par with the other government
You are
teachers?
at par with the regular teachers as per the agreements, as per the documents, all salary, benefits, everything.
No, my
Except
lord.
that
No, there are issues.
status is that of a contractual.
Well, there are issues. Like for, my lord, there is a circular, my lord, by the government in respect of, my lord, appointment or the benefits given for those people who die in harness. Your Lordship, at a point of time till 17, my lord, a post is given to the nearest kin, my lord, who is qualified. Now that is changed in the year 2017. Now the salary is allowed to be drawn to the retirement of the deceased person, and thereafter my post is also offered in case. Now that is not there in our case. And what they have given us, my lord, is 5 lakhs, a lump sum amount money. One of us dies in the harness. And it is very difficult, very cumbersome procedure. So not only many have lost lives, but many have lost lives, and the families are without this relief also 5 lakhs. So these differences are there. And this means a lot, my lord. Your Lordship will kindly come to page 258. Clause 9.3.1. Teacher's salary, my lord. AB expressed concern over large number of vacancies and advised the state to fill up the vacancies borne on the state budget first. Funds for new recruitments under SSA would be approved only when all the state vacancies are filled up. DAV also advised the state to do away with the dual cadre of teachers. This is what is relevant. So there must be one cadre. They advise the state to do away with the dual cadre of teachers, as all the teachers belong to the state. So this was the from the principal, my lord, contributor to the salary, because the majority of the amount as of now, as I have been informed, 75% is still owned by the government, and rest 25% is by the state. And this is also supported in the affidavit, madam, filed by the Union of India in this case. Your Lordship, then your Lordship had just inquired, my lord, whether we have raised these points earlier, my lord. So Annexa 7 page, starting page 265, my lord, are our representation. From 2017 onwards, man, we have been taking up these issues with the competent authorities. We accept all the, my lord, the benefits that came our way, my lord. It's like
The benefit of 7 pay commission.
yes, my lord, that is given, my lord. I had already
Not a whisper that you should be regulated. Great pay.
and my lord, seniority with retrospective. Now, what has happened, my lord? When they introduced, they introduced a scheme for regularization with undertaking in dotted lines. Man, I'll come to that later. Man. Year 2020, my friend. Now, what has happened, my lord? These stat teachers were appointed in stages. Like we were appointed, the majority was appointed in the year 2012 or 13. The advertisement came in. Then in 2017, then 2021, like that. So when the scheme was for regularization was introduced, some have gone away. It's a fact because they don't stand to lose. If one is young in age and one is appointed in the year 2017 and 2021, that scheme was introduced in 20 months. They have gone there. But for us, who has already served for a decade or so or more, we stand to lose that seniority. In fact, some of us are in a year or two are retiring. They are reaching their superannuation age, 60.
Accepted this.
My lord, we would have accepted if they had given us, my lord, if they had put us at par with all other batches. You introduce a scheme whereby, my lord, 1 or 2 batches are benefited. The rest are
Benefited in what way?
because they were appointed in the year 2017 or in 2021. So they can opt for that regularization scheme
Were appointed
in 2012.
as a contractual.
All were appointed, even those batches who had come later, they were also appointed contractual. But then they got benefited by the introduction of this scheme. But not in our case, madam.
Introduction of what scheme?
This madam, regularization scheme. They did regularize, but that is in the your lordship will find there is an IM, connected IM. It is there.
This matter.
Yes, madam.
The IA 620.
Or 8 madam.
48. IA 248. IA 248.
Madam, your lordship has to come to the last 2 pages of that.
Last 2 pages.
Oh, actually, the names, my lord. Readings are not much, but then these names have make it cumbersome.
1041.
Fine. Page 2 to 4, madam, may I read out?
Yes.
He said, come from Secretary to the Government of Assam, Department of School Education. Regarding options in respect of service conditions of contractual teachers and state school teachers under Samagra Shiksha Assam. With reference to the subject cited above, I am directed to enclose here with the model format of options for the contractual teachers and state pool teachers working under the Samagra Shiksha Assam, presently working in the elementary schools of the state. The said category of teachers are to voluntarily opt either for regularization of services with initial scale pay benefits from the proposed date of joining date that will be fixed in due course. Your lordship will kindly say, but they didn't even fix the date and they allowed us to exercise our options in due course, or to continue as contractual teachers with their existing financial benefits and service conditions. The model format should be circulated immediately amongst the said category of identified teachers. The last date to submit the filled up model format as is fixed on 30th January 2023, and the filled up model format should be submitted to the Mission Director SSA Assam by 5 p.m. on 30th January 20. Any teachers of the said category who shall not furnish the model format of options by the fixed date, their services shall be treated as continuation in the contractual terms and conditions with existing financial benefit. No absentees or left out or changes shall be entertained after the fixed date. The entire exercise may be coordinated with the DMCs, district mission coordinators of the district and the SSA Assam most urgent. Now, my lord, it also enclosed, as I had already submitted, my lord, they didn't even fix the date from which day this was to get the effect, my lord. Then annexure B, man. This was the model format. Great model format, man. Your lordship will see the dotted lines working as a for the name of the teacher under so and so. At district do hereby voluntarily and at my own sweet will, and further being well conversant with the terms and conditions, more particularly the choosing the option for regular service under the Government of Assam shall entail entitlement of initial pay in the pay scale commensurate with the post up to come under the service of Government of Assam as regular teacher with effect from the date is not. The declaration and consent hereby given shall not be modified or after joining as regular, I shall have no indefensible right to claim to pay protection in future consequent upon joining as regular teacher under government order, the deed of agreement is executed earlier, which suppose shall stand automatically dissolved, expired, terminated. So those are the benefits that was given to us if we had signed this agreement with dotted lines. And your lordship will recall that para 89 of Brajonath Gandhi. So we objected to it by file this, and there is an interim order operation. Now, my lord, coming back to my writ petition once again. Now, my lord, your lordship will kindly come to my lord, page 281 and 282. This was an OM, my lord, office memorandum dated 22nd of July 2019, issued by the additional chief secretary to the government of Assam. My lord, the last paragraph at page 282. And the last paragraph, page 282. Therefore, it is hereby clarified that in public interest, whenever advertisement shall be issued for filling a permanent vacant sanctioned post of teacher in primary or lower primary school, these contractual teachers, meaning husband, will be eligible to apply, provided that they continue working as contractual teachers without any break and if otherwise eligible. The TET qualifications acquired by the concerned incumbent in 2012 or later shall remain valid till they would be absorbed against permanent posts in accordance with the acts and rules in force. Such teachers are not required to acquire. So, initially, TET qualification, my lord, was for a particular tenure, so that is withdrawn by this. So we have remained qualified. And here they also say that till they would be absorbed against permanent posts in accordance with the acts and rules in force. Acts and rules, obviously, are the right to Education Act and the rules. There are two sets of rules under that. One is central and one is state. They filed affidavit against it, I'd just like to point out that affidavit filed by the Union of India. There was an affidavit filed by the Union of India. But I can give only the internal pages. This is not doesn't carry the. Huh? Yes, my lord. This affidavit was not filed in this case, but in the item number, Sondojjo Sutia, item number 15, Item 15. I'm sorry. Sondojjo. 22 months. Just to show, that they supported our case of doing that, or doing away with the dual cadre. WPC 8226 of 2019. First to the same document, that we have annexed to the writ petition in this case, in item 14, The affidavit filed by the Union of India. India Lordship Body. Paragraph 6. The affidavit is by one Tejpal Singh.
Yes. Para 6.
Para 6. May I read out? That as regards statements made in paragraph 9 and 10 of the writ petition, the deponent begs to state that the Project Approval Board of the Ministry of Human Resource Development in its 213 meeting advised the state government to do away with the dual cadre of teachers as all the teachers belong to the state. However, decision in this regard is to be taken by the state government. But the recommendation was, that we should have one cadre and no distinction between regular set of teachers and another set of teachers with the benefits, mostly of regular teachers, but put in place as a contractual.
Take us to that advisory again. That PAB.
PAB, Project Advisory Board. So this is supported by them.
Take us to that advisory.
Oh, that is in writ petitions. That is at page 251.
5.
1 of the writ petition in Jitu Topan Soikya, item number 14. The relevant page is 258. Clause 9, stop 3, stop 1.
What is the status of this PAB? What is it?
Well, this is the board, my lord, that regulates the entire scheme of things, my lord, including finance, under the Human Resource Development Department, my lord, in the government of India.
You are referring to page number?
258. Same thing, my lord, same assertion. At the bottom, 9 stop, 3 stop. PAB expressed concern over large number of vacancies and advised the state to fill up the vacancies borne on state budget first. Funds for new recruitments under SSA would be approved only when all the state vacancies are filled up. PAB also advised the state to do away with the dual cadre of teachers as all the teachers belong to the state. This is very relevant, my lord.
What is the meaning of dual cadre?
Dual cadre, my lord, they put teachers in the regular, my lord, in the, as regular employees and us, my lord, with the same qualification.
We don't belong to a cadre.
My lord.
Technically,
Well, that is what they cannot treat us like that. That is my submission.
That's what we want. In what context was this made? Dual cadre.
Dual cadre, my lord. You cannot have a set of teachers working as a on contractual
is
basis.
Is there any other
reference?
to
I know, I understand.
give us a little more clarity?
Yes, I understand. My lord, Annexure 7265, my lord, page 265. This is a communication from Commissioner Secretary, Government of Assam, to the Mission Director, SSA Assam. May I read on? In inviting to a reference to the above, I am directed to state that from the beginning, it was decided that the contractual LPUP teachers under SSA will get same benefit of regular teachers. Under the Directorate of Elementary Education, Assam, it is informed that it is decided that the contractual service of LP and UP teachers under SSA will get same benefit as that of regular under the Directorate of Elementary Assam with effect from 1/4/2017. Accordingly, you are requested to extend the 7-pay commission benefit to the contractual teachers of SSA with this was in perhaps my context to that extension of 7-pay commission benefits. Anyway, I'm just reading up. Here it may be pointed out that regarding allowing of grade pay of rupees so and so to unpaid graduate teachers as per 7-pay commission under the Directorate of Elementary Education Assam, who have been drawing grade pay of 2500 as per ROP 2010, the matter was referred to Finance PRE Department. So there was a difference, initially. And as per their advice, the matter has been placed before the anomaly committee and their decision recommendation is awaited. Huh? 7-pay commission negative, that has been reversed. There is another documented annexure 8. This also has nothing to do with well cadre, but that here also it says the anomaly committee and their decision recommendation is still awaited. Page 268, bottom line.
Grade pay.
Yes, madam, grade pay. there was a difference, my lord. Grade pay of 8700 to untrained graduate teachers was 7 and under deduction. And we are getting 2500 as per ROP 2010. Ultimately, that might not is cleared, madam, in course of time. My instructions. So far as the PAB well gather, but that has been the stand, madam. Then, madam, I'll just like to place my other. Now, your lordship will kindly come, madam. Madam, there are two sets of rules under this RT Act, madam. The Right to Education Act,
What is this? Page 281.
81. This is the number that I had read out a little while ago, madam. Page 282, madam, the para at the end. So, from the government of Assam. There you go. Therefore, it is hereby clarified that in public interest, whenever advertisement shall be issued for filling a permanent vacant sanctioned post of teachers in primary and lower primary school, these contractual teachers will be. They had given us some sort of benefit, madam, that which they thought that someday, madam, some advertisement will come out for regular appointment will be, madam, and that qualification will be extended to the till that date. This is what is meant by this plan. These contract teachers will be eligible to apply. Eligible to with regard to, my lord, that qualification, provided that they continue working as contractual teachers without any break and if otherwise eligible. The that qualifications acquired by the concerned incumbents in 2012, like us, madam, or later shall remain valid till they would be absorbed against permanent posts. In accordance with the acts and rules in force as mentioned above, such teachers are not required to acquire fresh state qualification. However, they will have to comply with all other requirements. It was an extension of the qualification. That qualification.
Yes.
Madam, the principal act, as your lordship is aware, madam, is the 2009 Act, madam, right to education. Madam, there is state rules framed under the Act, madam, in 2011, madam. And of that, madam, Rule 18 sub-rule 3, madam. Your lordship has got that. Yes, madam. The provision is under section 23 of the Act, and this particular two rules, madam, relating to salary and allowances and conditions of service of teachers for the purpose of section 23. State rules of 2011.
No, you are referring which rules?
My lord, the right to education, right of child to free and compulsory education Act, my lord, 2009, and then the two sets of rules. The principal
One is 2011.
2011 is a state rule, my lord. And then, my lord, the central rules. Same thing is provided, my lord, is 2010.
State rules.
State rules, my lord, Rule 18. Period allowances and conditions of service. The government autonomous council, three, my lord, your lordship can come straightway to sub-rule 3, my lord. The scales of pay and allowances, medical facilities, pension, gratuity, provident fund, and other prescribed benefits of teachers, including those employed for the purpose of imparting special training as specified in section 4, shall be that of regular teachers and at par for similar work. This is very relevant, my lord, in my humble submission. Similar rules, my lord, is provided for in the central rules also. That will be, my lord, rule 20. I can only for this purpose, I can place this. I have got also one copy. 22. That page, man. At the
20.
bottom, 20th sub-rule 3, man. Same thing is stated there. I know in respect of these agreements by which I say, my lord, even though under compelling circumstances I had to sign it, I say those to be of unlawful nature in this sense, my lord, that for model employer, my lord, they cannot put us even if we are appointed under that conditional appointment, my lord, contractual, my lord, they should have or they cannot, my lord. And the law has been cleared, my lord, particularly after that Bhulanath case, my Bhulanath case, my lord, that is very recent. 2026 case, my lord. I'll just place it. But before, I'll just read to, I'd like to, my lord, read out that section 23 of contract agreement. so far as the agreements, my lord. The agreements that, which is it's two agreements that we have signed, and also the one they wanted us to sign, my lord, which we didn't. That with dotted lines. Contract. Now, my lord, in the context of those agreements, my lord, which I say illegal, my lord, section 23. The
Yes.
the consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted, it would defeat the provisions of any law. Not fraudulent, so involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. In each of these cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. And the purport of the scheme itself, my lord, is to have a regular cadre, single cadre, my lord, of teachers. And who had introduced this scheme, my lord? Not the state, the center, the government of India. And their guidelines suggest that you have a regular cadre and they give them all the benefits of regular teachers. Keep a single cadre, my lord. And the authority in the state acts otherwise, my lord. Somehow or the other, my lord, keeping us under, my lord, well, my lord, we can't choose, my. We're not in that. We have not been placed like that, my lord. It is very easy to say, my lord, that yeah, you have signed that agreement, so you're bound by it. But under what circumstances, my lord? Or do I face unemployment with all my qualifications? And where there is no bar, my lord, they swear by that act, my lord, the 2009 Act and the rules, which rather provide for contractual appointment.
Let us come to that RTE again. Section.
My lord, the rules. Section is 23. You know, look up, man.
Which section? 23 of?
RTE Act, under which, my lord, should be placed at the same status as any other regular teacher.
Where does it say 23?
23 of the Act, and the rules, my lord, 20 subclause 3 and 18 subclause 2.
23 is for appointment in terms of conditions.
Yes, my lord. Terms and conditions. Under that, my lord, these two rules are framed, one by the state and one by the center, my lord, by the union, and both are, my lord, identical. Provision in the statute, in the Act is 23.
Is come to 23.
Yes, ma'am. But qualification for appointment and terms and conditions of service of teachers. Any person possessing such minimum qualification is laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Where a state doesn't have adequate institutions offering courses or training in teacher education or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years, as may be specified in the notification, provided that a teacher who at the commencement of this act does not possess minimum qualification laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. The salary and allowances payable to and terms and conditions of service of teachers shall be such as may be prescribed. Under this 3, 23(3) rules, my lord, 18 in case of state rules and 20 in case of, my lord, central rules have been framed. And they pointed, my lord, nothing but equal status. So far as qualification is concerned, we carried a qualification.
Where does Rule 20 say that you are to be regularized or benefits of
Benefits of regular,
ultimately
it does
services
say,
to
my lord,
be
it
granted
does say.
by way of regularization?
But it doesn't
20
speak
merely
in so,
says
doesn't speak in so many words, but then the
we have
purport
to
of the
restrict it to the terms used. 20 merely says that the salary must commensurate with your qualification.
well,
It be at par for similar qualifications,
Yes, yes.
work and experience. There is a parity to be maintained.
well,
But where is this argument you are making the ground that the single cadre
well,
must be the government cadre? State rules.
18(3). Huh? I don't know. So Lordship will kindly come to the state rules, man. State rules.
18.
Yes, ma'am.
Yes.
My lord. 20%. 18, my lord. Salary and allowance and conditions of service of teachers for the purpose of section 23. There it is.
Yes.
18, rule 1 first, man. the government, autonomous council or the local authority, as the case may be.
Yes.
Autonomous council or the local authority, as the case may be, shall notify terms and conditions of service and salary and allowances of teachers in order to create a professional and permanent cadre of teachers. That is 18.1.
Read 18.3.
And 18.3 is thereafter, what will be the entitlement?
Please read.
The scales of pay and allowances, medical facilities, pension, gratuity, provident fund, and other prescribed benefits of teachers, including those employed for the purpose of imparting special training as specified in section 4, shall be that of regular teachers and at par for similar work and if we now read both these provisions together, my lord, your lordship will first, my lord, they say create a professional and permanent cadre of teachers. Single cadre.
Doesn't talk about government cadre.
My lord.
Doesn't necessarily mean a government cadre. Permanent cadre. It could be a permanent cadre or contractual teacher.
Permanent regular cadre, obviously, my lord, it has to be.
Less.
So we are no.
Less insurance. Because if you read 1 and 3,
Yes, ma'am.
3 particularly, it says your salary shall be at par with that of regular teacher.
My lord.
So which contemplates.
And also, my lord, at par for similar work and experience. We are discharging the similar duties, my lord. So for that, one set of my lord, employees are given tax benefits.
No, that's quite right. Your similar work, you should be
My
given the
lord.
same benefits.
My lord.
No quarrel on that.
My lord.
But does it necessarily mean that you become a part of the government?
No, unless they allow us, my lord, how can we? But the laws are perfectly in consonance, my lord.
Your demand before the court is that you should be regularized.
My lord.
On the interpretation of these rules. That is what
With retrospectivity.
With retrospective.
Right.
Retrospectivity will come later. Now you tell us that on these rules, the only condition that comes is that you must be a regulator. I mean, government. Or you could not have been appointed otherwise than by way of a regular process.
Exactly, ma'am. That is my argument. That is why I am attacking this, my lord, the agreements, ma'am.
Okay.
Not they, my lord. We have been representing, my lord, on that day, my lord, after our selection, my lord, we are so happy, my lord, we got ourselves jobs. We could carry home some salary, my lord, whatever that came our way, man. We didn't have any option, man. We are beggars.
But you knew.
My lord.
But you knew that this was a contractual at the end of the day.
My lord, we were not so naive, my lord. That is admitted, man. But can they do it or can
better
they cannot?
To have something than nothing at all.
Yes, man.
We give you that.
That's why I said, man, otherwise we would have been roaming around unemployed. Well, government is the.
We are trying to understand
I
your argument. Say that the RTE Act, central rules, state rules, PSC advisory points only to a regular government cadre. There can't be any other cadre.
Right.
Whatever exigencies we may have done is a different issue. Ultimately, it must be a government.
Exactly.
But that we are unable to read it.
My lord, these statutes are made, my lord, only for the purpose of, my lord, running the government, man. And these are not framed for, my lord, some private concern, man. And we cannot envisage a situation where, my lord, and we are working
then the question of your appointment through that SSA or RMSA comes in.
No, SSA.
SSA.
Earlier, Sorbo 6
What
and now
is the role of these SSA?
Madam?
What is the role of these SSA? When the government, the education department is there, with its pyramidal
basically, this is to fill up the gaps, man.
Huh?
Basically, this is to fill up the gaps.
What gaps?
The standard of education, my lord, and outreach of education in the interior areas, my lord.
Right.
Rural areas.
So what stops the government from doing it from a regular point to regular?
That your lordship, these questions to the my learned friend.
Yes, Mr. Harunier. What is the concept of ICC?
See, it's a central scheme, it's not a state scheme. It's a central scheme, and it was introduced so that in the entire country, the education system can be central, provided fund to the state.
What happens to the teachers who are employed in the after they develop the education? They go back home, taking away only their salary, as compared to their counterparts in the government department. The equal service or lesser.
There is scheme in other states also they have absorbed in the regular cadre. They have been absorbed in the regular cadre subsequently.
You are also contemplating to do that.
Yes, madam.
But without giving them the benefit of earlier service.
Well, because they are getting all the benefit, madam. They are getting the regular salary, they are getting the except pension, they are getting all the benefit. And from the prospective date, they will get the all benefit, madam.
How will you work out their pensionary benefits?
It's NPS, madam. Because
NPS is contributed.
Yes, madam.
So their contribution starts from the day they are regularized.
Yes, madam.
And supposing somebody retires in the next 2 years, what contribution will they get?
But then they will not get the whole pension scheme because they have joined after 2005, madam.
Why? That is why they are claiming for retrospective benefit.
No, in any case, because they have joined in the year 2012. So in any case, they will not get the benefit of OPS.
But from 2012, there was no contribution.
No one.
Because the date, my lord, will come, they will leash us, and they
You allowed them waiting. Can you raise this question after long 14 years?
No, we are not sitting tight, my lord. They are undo nonsense on that.
Right.
Now, my lord, I'll just like to cite a few.
Yes.
My lord. First, I will come to my lord Nihal Singh versus State of Punjab, my lord. I'd like to quote para 14. 2013-14 SCC 65.
Their posts were directed to be created. Here the posts are available.
But they are not giving us the benefits of those posts, my lord. Why are you curtailing them?
Yes, please. Citation.
My lord, it is 2013-14 SCC 65.
6.
5. Page 6.
658.
My lord.
Page number?
65, my lord. 14 SCC 65. Para 24. It reads, my lord. Initial appointment of the appellants can never be categorized as an irregular appointment. The initial appointment of the appellants is made in accordance with the statutory procedure contemplated under the Act. The decision to resort to such a procedure was taken at the highest level of the state by conscious choice, as already noticed by us. In view of the above, at para 39 of the Honorable Apex was pleased to direct the state. Well, this is in context of because it was the state at that time in this particular case, even though they were working in that bank. But they were selected by the state man. Only thing, their salary was being paid. Here, also there is a regular procedure of selection. And we were inducted through that selection process. And now, my lord, government cannot shirk its responsibility, my lord. Okay, you receive this and then. That is one, my lord. And all the time, my lord, all the while, my lord, we are discharging the same very duties and perhaps more, my lord, because we are, I shouldn't say this, that they are good teachers earlier also, now also. But having said that, my lord, I have come across many of them, my lord, during this thing. And they're quite smart, my lord, computer savvy. All the time, my lord, they are in terms with sending statements every week, every fortnight, my lord. And what they are not doing, my lord, from flood relief to everything, my lord, census duties, Gudotsav, and even, my lord, discharging duties in respect of these schemes, my lord, the government for the social schemes. They are doing those works also. Then, my lord, one other case, Jago, man. Jago is 2024 SCC online, Supreme Court 3826. I can.
Yes.
But here, my lord, paragraphs, my lord, 20, 21, 22, 25, and 25, 26, 27. Distinguished Umadevi in this case. My lord.
Paragraphs again.
Para 20, 21, 22, 25, 26, and 27. For para 20, I just like to read off. It is well established, as you also established, that the decision in Umadevi doesn't intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumental. This judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis. It says so, man. Inherently required on a regular basis can over the time transform what was initially ad hoc or temporary into a scenario demanding fair regulation. In a recent judgment of this court in Vinod Kumar versus Union of India, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary but has performed the same duties as performed by regular employees over a considerable period in the capacity of the regular employee. The relevant paras of the judgment are quoted, 6 and 7, man. That copy, possibly I can give. I am carrying that Vinod Kumar. Here also they have distinguished that. The application of the judgment in Umadevi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific application for vacancies and the subsequent circular followed by the selection process involving written test and interview, which distinguish their case from the appointments through backdoor entry as discussed in the case of Umadevi. The judgment in the case of Umadevi also distinguishes between irregular and illegal appointments, underscoring the importance of considering certain appointments even if were not made strictly in accordance with the prescribed rules and procedure cannot be said to have been made illegally if they had followed the procedures of regular appointments, such as conduct of written examinations or interviews as in the present case. Then, my lord, paragraph 21. The High Court placed undue emphasis on the initial label of the appellant's engagements and the outsourcing decision taken after their dismissal. Court must look beyond the surface levels and consider the realities of employment, continuous long-term service, indispensable duties, and absence of any bona fide or illegalities in their appointments. In that light, refusing regularization simply because their original terms did not explicitly state so, or because an outsourcing policy was belatedly introduced contrary to principles of fairness and equity. Then the paragraph, the purposive misuse of temporary employment contracts as exemplified in this case reflects a broader systemic issue that adversely affect workers' rights and job security. This is important. In the private sector, the rise of the gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploitative employment practices. When public sector entities engage in misuse of temporary contract, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in government operations. Then, my lord, your lordship will kindly come to page 25, para 25. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the fundamental purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Misuse of temporary labors. Employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. Such misclassification deprives workers of the dignity, security, and benefits that regular employees are entitled to, despite performing identical tasks. Why not this? I'm skipping this arbitrary termination. The lack of career progression. Temporary employees often find themselves excluded from opportunities for skill development, promotions, or incremental pay rises. They remain stagnant in their roles, creating a systemic disparity between them and their regular counterparts, despite their contributions being equally significant.
That is what we were trying to understand.
Yes, madam.
That concept of appointment
On contract
contractual
basis.
teacher, why was it required?
Exactly.
Was there no vacancy? Were there new schools? Were there no children to be educated? What was it?
Exactly.
Why was it done to particular scheme when it could have been done by the government? By giving an open admission.
One reason was, my lord, not sure, my lord, cut down on, my lord, the state exchequer expenses. Maybe, I don't know. Although it is not envisaged in law. Take someone's service, you pay him, and in case of any other person charging the same service. Why the conditions are separate with different. And my lord, similarly placed personnel with same qualification, my lord. Difficult to understand.
Okay.
And then, my lord, and denial of basic rights and benefits, my lord.
These are not in your case, are they?
My lord, it touches on the, my lord, the nature, my lord, here it context was something else, my lord. These are the principles of that must be followed by every employer. Otherwise, why would we be here? Yeah, my lord, after Jago, my lord. Then, my lord, I'd like to cite, my lord, this case, my lord, Bholanat versus State of Jharkhand and others. Reported recently, my lord, 2026 SCC online, Supreme Court 129. Two 2026 SCC online, Supreme Court 129. Is from Jharkhand.
Page number again.
Page number, my lord, 129. Supreme Court 129. My lord, in para 12, it says that an unfair and oppressive contractual term imposed by a stronger party upon a weaker party having no bargaining or meaningful choice be declared as void. Also relied, my lord, in the connected case of Paniram. The 11th para that I would vouch, my lord, would be para 13, my lord.
Bholana.
My lord, Bholana.
Bholana.
13.1, 13.2, 13.3, 13.4, 13.5, 13.6, 13.7, 13.8, 13.9, and 13.10. And in para 14, my lord, the conclusion, my lord. I'll just read out, my lord, para 13.1. Para 13 speaks of, my lord, once again, my lord, of legitimate expectation of the employees. Another facet requiring consideration in the case of contractual employee, such as present appellants, is the doctrine of legitimate expectation, where employees have continued to discharge their duties on contractual posts for a considerable length of time. As in the present case, but natural that a legitimate expectation arises that the state would at some stage recognize their long and continuous service. It is in this belief, bolstered by repeated extensions granted by the executive, such employees continue in service and refrain from seeking alternate employment, notwithstanding the contractual nature of their engagement. At this juncture, it is thus opposite to advert to the principles governing the doctrine of legitimate expectations as enunciated by this court in Army Welfare Education Society by Sunil Kumar Sharma, wherein it was held as follows. A reading of the aforesaid decisions brings forth the following features regarding the doctrine of legitimate expectations. First, I am not reading out the para number quoted. First, legitimate expectation must be based on a right as opposed to a mere hope, wish, or anticipation. Secondly, legitimate expectation must arise either from an express or implied promise or a consistent past practice or custom followed by an authority in its beliefs. Briefly, legitimate expectation operates in the realm of public law, that is, a plea of legitimate action can be taken only when a public authority breaches a promise or deviates from a consistent past practice without any reasonable basis. This may help your lordship, man. So they could have easily appointed us on a regular basis. Why did they appoint us? Then the aforesaid features, although not exhaustive in nature, are sufficient to help us in deciding the applicability of the doctrine of legitimate expectation to the facts of the case at hand. It is clear that legitimate expectation jurisprudentially was a device created in order to maintain a check on arbitrariness in state action. It does not extend to and cannot govern the operation of contracts between private parties wherein the doctrine of promissory estoppel holds the field. It is therefore not difficult to comprehend the expectation with which such contractual employees continue in the service of the state. The repeated conduct of the employer state in expressing confidence in their performance and consistently granting monetary upgrades and tenure extensions reasonably nurtures an expectation that their long and continuous service would receive further recognition. Then 13, stop 1 month. Another constitution bench in state of Karnataka versus Umadevi cautioned that the doctrine of legitimate expectation cannot ordinarily be extended to persons whose appointments are temporary, casual, or contractual in nature. The relevant extract of the judgment reads as follows: when a person enters a temporary employment or gets engagement as a contractual or casual worker and the engagement not based on a proper selection as recognized by the relevant rules. In here, our nature of appointment is different. He is aware of the consequences of the appointment being temporary, casual, or contract nature. Such a person cannot invoke the theory of legitimate expectation for being confirmed in the post when an appointment to the post be made only by following a proper procedure for selection and in cases concerned in consultation with the Public Service Commission. Therefore, the theory of legitimate expectation cannot be successfully advanced by temporary, contractual, or casual employees. It cannot also be held that the state has held out any while persons either to continue there or to make them permanent. The state cannot constantly make such a promise. Also, here the this is what was spoken in Umadevi. However, this court in Umadevi clarified that the bar against invocation of the doctrine of legitimate expectation applies only to those temporary, contractual, or casual employees whose engagement was not preceded by a proper selection process in accordance with the extent rules. Consequently, where such engagement is made after following a due and lawful selection, but there is no absolute bar in law preventing such employees from invoking the doctrine of legitimate expectations. Then 13. In the present case, the respondent state had engaged the services of the applicants on sanction post since the year 2012. It was only towards the end of the year 2012 that the respondents communicated that no further extension. In that case, Malon, no further extension of the appellant's engagement was likely to be done. Then 13.3. In our considered opinion, the aforesaid action is not only initiated by arbitration but also in clear derogation of the equality state. Initially engaged the appellants in the state initially engaged. Sorry, the respondent state initially engaged the appellants in their youth to discharge public duties and functions. Having rendered long and dedicated service, the appellants cannot now be left to fend for themselves, particularly when the employment opportunity or no longer accessible owing to age constraints. So we are unable to discern any rational basis for the respondent state's decision to discontinue the appellants, but this is in respect of their discontinuance. Their conscience that this symbiotic relationship between the appellants and the respondent state was mutually beneficial. The state derived the advantage of the appellant's experience and institutional familiarity while the appellants remain in public service. In such circumstances, but this is described as public service, my lord. In our case, is lot better, my humble submission. In such circumstances, any departure from a long-standing practice of renewal, particularly one that frustrates the legitimate expectation of the employees, ought to be supported by cogent reasons, record in a speaking order. Then, such a decision must necessarily be conscious and reasoned one. An employee who has satisfactorily discharged his duties over several years and has been granted repeated extensions cannot overnight be treated as surplus or undesirable. We are unable to accept the justify advanced by the respondent as the obligation of the state as a model employer extends to fair treatment of its employees irrespective of whether the engagement is contractual or regular. This court has on several occasions deprecated the practice adopted by the states of engaging employees under the nominal levels of part-time, contractual or temporary in perpetuity and thereby exploiting them by not regularizing their positions. In Jago, the one which I have just read out, the Union of India, this court underscored that government departments must lead by example in ensuring fair and stable employment and evolve the test of examining whether the duties performed by such temporary employees are integral to the day-to-day functioning of the organization. In Sripal versus Nagar Nigam and Vinod Kumar versus Union of India, this court cautioned against mechanical and blind reliance on Umadevi to deny regularization or to temporary employees in the absence of statutory rules. It was held that Umadevi cannot be employed as a shield to legitimize exploitative engagements continued for years without undertaking regular recruitment. The court further clarified that Umadevi itself draws a distinction between appointments that are illegal and those that are merely irregular. The latter being amenable to regularization upon fulfillment of the prescribed condition. Haram Singh versus State of UP, this court strongly deprecated the culture of ad hocism adopted by the state's India capacity as employer. The court criticized the practice of outsourcing or informalizing recruitment as a means to evade regular employment obligation, observing that such measures perpetuate precarious working conditions while circumventing fair and lawful engagement practices. The state must remain conscious that part-time employees such as the appellants constitute an integral part of the edifice upon which the machinery of the state continues to function. They are not merely ancillary to the system, but form essential components thereof. The equality mandate of our constitution, therefore, requires that their service be reciprocated in a manner free from arbitrariness, ensuring that decisions of the state affecting the careers and livelihood of such part-time and contractual employees are guided by fairness and reason. In the aforesaid backdrop, we are unable to persuade ourselves to accept the respondent state's contention that the mere contractual nomenclature of the appellant's engagement denudes them of constitutional. The state, having availed of the appellant's services on sanctioned posts for over a decade, pursuant to a due process of selection and having consistently acknowledged their satisfactory performance, cannot, in the absence of cogent reasons or a speaking decision, abruptly discontinue such engagement by taking refuge in formal contractual clauses. Such action is manifestly arbitrary, inconsistent with the obligation state, act as a model employer, and fails to withstand scrutiny under Article 14 of the Constitution. No better explanation violation of Article 14 can be put. Now, my lord, therefore, this was allowed, my lord. In light of our discussion in the foregoing, for we summarize our response state was not justified in continuing with the appearance of sanctioned vacant posts for over a decade under the nomenclature of contractual engagements, and thereafter denying them consideration for regularization. Abrupt discontinuance of such long-standing engagements solely on the basis of contractual nomenclature without the recording. In our case, we have not been discontinued. For passing a speaking order is manifestly arbitrary. Contractual stipulations purporting to bar claims for regularization cannot override constitutional guarantees. Acceptance of contractual terms does not amount to waiver of fundamental rights. This is very important. And I rely on this. And contractual stipulations cannot immunize arbitrary state action from constitutional. The state as a model employer cannot rely on contractual labels or mechanical application of Umadevi to justify prolonged adhocism or to discard long-serving employees in a manner inconsistent with fairness, dignity, and constitutional governance. In view of the foregoing discussion, we direct the respondent state to forthwith regularize the services of all appellants against the sanction post to which they were initially appointed. The appellant shall be entitled to all consequential service benefits accruing from the date of the judgment. Accordingly, the present appeals are disposed of and all represented. My Lord Binod Kumar, if your lordship wants, my Lord, I can place para 6 and 7. Binod Kumar, my Lord, 2020. 1 SCR 1 to 3 or my Lord 2024 also 2024 INSC 33. This was first, my Lord, against judgments delivered by the Central Administrative Tribunal, my Lord, and the High Court. In para 6 and 7, my Lord, 2 paragraph, short paragraph, just like you read on it. Okay. Para 6 and 7. The application of the judgment in Umadevi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period to continuous service. Their promotion was based on specific notification for vacancy in a subsequent circular, followed by a selection process involving written tests and interviews, which distinguishes their case from the appointments through backdoor entry as discussed in the case of Umadevi. The judgment in the case Umadevi also distinguished between irregular and illegal appointment, underscoring the importance of considering certain appointments even if they are not made strictly in accordance with the prescribed rules and procedures, cannot be said to have been made illegally if they have followed the procedures of regular appointments, such as conduct of written examination or interview, as in the present case. Paragraph 53 of the distinguished, my Lord, this Umadevi's case, which is not applicable to the cases of nature as in our. So therefore, my Lord, I conclude my argument saying, my Lord, in all respect, my Lord, first of all, man, they should have, or they couldn't have, my Lord, appointed us on contractual basis. That is number one. It is either in keeping with the scheme of Samagra Shiksha or in keeping with the provisions of the 2009 Act and the two rules, state rules of 2011 and central rules of 2010. Section 23 of the Act rules 20 and 18 of the state rules, 20 of the state. Then, my Lord, The other things, man, I had mentioned, man. For one thing, man, the primary, man, consideration is our seniority. If the seniority is reckoned from the date of appointment, man, all that is commensurate with that, man. Your lordship rightly pointed out, man. Even if it is not OPS, even if it is NPS, man, what about my the contribution that I could have made during that period, man? And my lord, that the application of the 2017 circular for those persons, my lord, dying in harness, what do they get? In their case, my lord, they get the benefits, my lord, the salary of the deceased employee till the date of retirement to the family member, and thereafter again, my lord, compensation appointment. And in our case, my lord, we are given a paltry sum of rupees 5 lakhs, and it's very difficult to get. That is what has been submitted, my lord, instructed to me. Because some of the petitioners have died, my lord.
That is in the events such a situation arises.
But it has
Or
arisen.
there is-
It has arisen. So, yeah. And some are facing retirement, man. Very soon, money in a year, in a couple of years. After the submission. Oh, man, 3 items, man, I have here, man, 14, 15, and 22.
Right.
One is upper primary, other two are lower primary.
So meeting is hearing in item number. Item, what are the items you are?
Items, my lord, 14, 15, and 22.
15, 20.
And one other case, my lord, that your lordship will find reference, my lord, that is on the question of dotted lines, my lord. The model format that I had shown, my lord.
What are your item number?
14 and 22. One other, that other matter, inland water case, matter, Rajanath Ganguly's case, para number 18. It is quoted in Vlada's case. No? It is quoted in
Unconscionable terms.
my lord. Conscionable, that
Unconscionable
unconscionable, my lord.
terms of
That
the
word was used, my lord. Unconscionable.
Lion.
That, my lord, the entire para, my lord, so relevant, it was relevant then, it is, my lord, unfortunate that it has still become relevant, my lord. The same situations we are facing, my lord.
Why is it unfortunate?
No, my lord. See, my lord, somebody powerful, my lord, the government is dictating terms to us, my lord. We need employment. What can we do? Huh? And one other case, my lord. I'm sorry, this is the last one. Paniram versus Union of India. Quoted in 2006, volume 4 SCC. My lord, para number 23. 2006, 4 SCC 1.
Page 1.
1. My lord. Paniram. It refers to that, my lord, this unfair and oppressive contextual term imposed by the stronger party upon the weaker one, having no bargaining or meaningful choice, declared as void.
That is Uma Devi.
No, my lord, this is Paniram.
No, this citation you are giving is the
No, one Uma Devi also starts at page 1, my lord.
2006 4 SCC page 1. Or is it the other way around?
No. My lord, it is quoted in Bolana. Bolana, my lord, the citation is Paniram. But I'll give them. During the Same thing is, my lord, asserted as in Brothanath Ganguly. The lion and the lamb. Your lordship require hard copies, my lord. I know. Much obliged.
Item 2.
Yes.
3. Sorry, Lordship, 3.
Your citation would be 2021 19 SCC 234.
Hold on, man, I'm grateful, man.
Paniram is yes, Your Lordship. 29.
Paragraph.
Lordship, we have 122 assistant teachers
Yes.
in upper primary, which is basically the class 8.
You are appearing in which item?
Item 3. Mohini Mohan Gogoi versus Union of India. 8824 of 2018. So we came to court in 2018. Lordship, very quickly, I'll just go through
Could you repeat the items again? Item?
item 2, item 3, sorry, Your Lordship, item 3. Writ petition number 8824 of 2018.
Yes.
Lordship, page 65 is how it begins, how we get in. Very quickly, I'll just go through the facts.
Yes.
Lordship, my instructions are we are the only batch who had pre-service qualifications. So we were qualified as per the Act and the rules on the date when we got appointed. Lordship, one of the advertisements is 14/2/2012, and it makes reference page 65. The reason I'm showing you, Your Lordship, because it is in compliance with Lordship has annexure 3, page 65. Annexure 3, page 65. I'm showing only to indicate a few things. It's February 2012 advertisement. It's with the view to support, strengthen, improve the quality of elementary education in the state of Assam in compliance with Right to Education Act 2009. Online applications are invited in prescribed form from eligible candidates in the following petitions under Ahom Harba Hikka Abhiyan. So it is to ensure compliance of Right to Education Act, and it is under Ahom SSA. And Lordship may come to page 67. After the chart, the first bullet, just to indicate the procedure.
Page
Last
58.
page 67. The same advertisement.
Yes.
This indicates the procedure that they followed. The first bullet, Your Lordship. After submitting the form, Lordship has, please get the printout of on so and so. The printed signed application should be submitted along so and so copies, etc. Experience, caste, disability, debt for further authentication before the scrutiny cum interview board for the district where he or she has been given preference. So there was a scrutiny cum interview board who was scrutinizing, and the selection process, there was an interview. My point is this mirrors a regular selection process. One more advertisement, Your Lordship, page 78. Just to take out any kind of contention that we were illegal. At best, we may have been irregular because they call us contractual. And this advertisement makes it even better. It talks about, with view to support, strengthen, improve quality of elementary education in compliance Right to Education Act 2009 in pursuance to government so and so as per provisions of Assam Elementary Education Provincialization Rules 1977. So they even follow the rules. So our selection procedure mirrors a regular selection procedure. And it is their advertisement, so there cannot be an argument that we are backdoor or illegal. And if we were, it is on them that they continued us for so long. That is the point, Your Lordship. From 2013, we've been given regular pay. As already brought to your notice, Your Lordship, Lordship has an additional affidavit that we filed. It will be page 115. Annexure 2 to additional affidavit filed by us.
Election
2. A notification of 1st July 2020.
Yes.
Lordship, just to show this is the position, this is what they've given us and what we are enjoying.
What does it say?
Yes. In pursuant to cabinet decisions of so-and-so to provide additional service benefit to 29701 assistant teachers in lower primary and upper primary working as contractual teachers under Ahom Korba Hikka Abhingan mission, who were engaged during the period of 2012-2017 and who joined their services on or before 2018 and were engaged to strengthen and improve the quality of elementary education in state in compliance with Right to Education Act 2009 and with a view to maintain pupil-teacher ratio. I'll come back to that, Your Lordship, but Lordship may just mark it. This is important. Why did they need us? Especially in the schools of remote and isolated areas, the government of Assam is pleased to notify the following benefits to the teachers. So they give us continuation of service till 60 years. That's number one. They give us medical reimbursement 5 years. They give us casual leave, earned leave, etc. E is what they don't give us. Pensionary benefit. And these are with effect from 1st July 2020. One other document, Lordship, I'll just show you so that I'm done with facts. We had to sign an agreement, first for 5 years. After that expired, we made to sign an agreement for 1 year, 11 months. And thereafter, there has been no agreement, but we have been continued. So at the moment, we have just been continued. But Lordship, why did we sign it? Page 129. To further my Central Indian line.
So there's moral. It's that contractual you sign.
Yes, yes, yes. Lordship,
Serve,
Lordship,
they've given you everything.
130,
The
page
only
130.
question is regularization.
Yes. Lordship, just to show the salary, page 130, this is their own letter asking us to sign. And they said that you sign first and then we'll process salary.
What is this agreement?
Agreement.
This is an agreement.
Yeah. Lordship, for first 5 years, we signed an agreement. And thereafter, there's been no agreement. Lordship, at one point of time last year, they regularized a whole bunch of people. They gave the option, which my learned friend has already mentioned. Some 17,000 teachers availed that option. The problem with an option is that, and the problem with their policy of regularization, which is why we came by way of an interlocutory application, and Your Lordship was pleased to grant us protection. Because we have the first initial interim order is that post to the extent of 121 in our case. That was the first interim order, must not be filled. So that remains vacant. Your Lordship was subsequently in 2025 did not disturb that, also protected us from exercising because there was like a Damocles' sword hanging on us that by so-and-so date, you either opt for regularization or not. And Your Lordship said that that option is not, by an interim order, Your Lordship said that option is not right and not valid and therefore not applicable, which is why we did not go that way and we are continuing. And the problem with that, with their regularization policy is after 15 years of service, last year, they gave us an option for regularization at initial pay. So you wipe out 15 years of service I'm getting some 50,000 plus. I'm told no, from today onwards, forget what you did for 15 years. You get now 17,000 plus. And that is their magnanimous policy of regularization, which we ought to have accepted, which we said we will not. And your lordship protected us, so we continue as original, and our writ petition is simpliciter asking for regularization. Asking for regularization on the ground of the law that if you've taken my service for so many years, it's antithesis to ad hocism to continue me on.
Essentially, it's a question of
It
pension.
is that. And lordship, I will
It's
quickly,
the pension that you want.
yes, and
Besides that,
seniority.
everything else you are getting.
Seniority. Lordship, the point is more than that. The point is almost every case I look, the final relief is regularization with every benefit. So why should we piecemeal it and say, I want this and I want that? If you have taken, and lordship, almost every case except a full bench of this court is not got to do with teachers who are complying with Article 21A constitutional obligation of the state. 21A is the genesis of Right to Education Act. The Right to Education Act and the Supreme Court upheld this act on the ground that it is absolutely and entirely incumbent on the state to provide elementary education. The rules require teacher-pupil ratio. You did not, out of charity, want us. You had to get us. If you did not, you violate 21A. Your lordship came from your lordship. Why did they do contractual? At the point of time when it began, there were not enough, and I'll show you that from your rules, lordship. There were not enough institutions where we could get the B.Ed degree. So the rules provided, and the route notices that and says, 5 years, we will appoint you, but within 5 years, you please get your minimum qualifications, which is why they said, okay, contractual. This is an unprecedented case, your lordship. There are work charge people, there are peons, there are clerks, and I'm not saying that they should not be regularized. They should be. Supreme Court, I have a list of 13 cases, and I'll give it to your lordship, where they have consistently held that this is not the business of the state to employ. This is not the business of the state in the manner of employment. You cannot. Uma Devi was anti-ad hocism. 2005. Facts. I've shown you the advertisement. We pleaded in paragraphs 2, 13, 12, 15 that we are eligible and we are pre-service qualified. Paragraph 2, 12 and 15. Now, lordship, the Assam Right to Education Rules, 2011.
Yes.
I'll take you quickly, lordship, because you've already. These are pursuant to Right to Education Act, empowering the state to give rules. Lordship, Rule 15 first.
The Assam rules.
Assam Rule. Does lordship have the same book?
Yes.
Then it's page 264. 5th edition.
64. RTE rules 2011.
11, yeah. Lordship, Rule 15 is at page 234. It begins at page 241. Yes. When it fell from your lordship, why did they go for contractual? They are in a better place to answer that, but maybe there's indication here, is my submission. Rule 15 is what prescribes, I want not read it, lordship. Rule 15 is minimum qualifications, and they are prescribed by NCT, National Council for Teacher Education, and there will be NCT, yes, your lordship. Then Rule 16 is important. Rule 16 says relaxation of minimum qualification for the purpose of section 23(2) of the main act. The government, which basically government of Assam, shall estimate teacher requirement as per the norms in the schedule for all schools referred to in clause N of section 2 within the state within 3 months from the date of notification of these rules. They have to estimate the number of teachers they require. Till the state does not have adequate institutions offering courses and training in teachers' education of persons possessing minimum qualification as laid down in Rule 15(2) are not available in sufficient numbers in relation to requirement of student estimated in Rule Sub-Rule 1 of under Rule Sub-1(1), the government shall request within 1 year of commencement of the act the central government for relaxation of the prescribed minimum qualifications. So because there are not enough schools, B.Ed schools, etc., where the teachers can go and get minimum qualifications, so there was a time period given, which is perhaps why they went for contractual, giving them some chance to acquire the minimum qualification, is if I'm giving the benefit of the doubt to the government. Now, Lordship 18 has already been read out to you. Lordship 18, salaries. Again, Lordship 23(3), Lordship remembers, of the Act says the state on terms and conditions as notified by the state. 23 of the Parent Act, Central Act, Right to Education 2009 Act says the state will then determine the terms and conditions of tenure and salary. So salary and allowances and conditions of service of teachers for the purpose of section 23(3). The government or autonomous council or local authority as may be shall notify terms and conditions of service and salary and allowances of teachers in order to create a professional and permanent cadre of teachers. Lordship 2B, in particular and without prejudice to Sub-Rule 1, the terms and conditions of service shall take into account the following, namely, B, provisions enabling long-term stake of teachers in the teaching profession. 3, the scale of pay and allowance, medical facilities, pension, gratuity, provident fund, and other prescribed benefits. So it's very, very specific. They don't just talk about scale of pay and allowance. It's medical facilities, pension, gratuity, provident fund, and other prescribed benefits of teachers, including those which are imparting specialized this thing, shall be that of a regular teacher and at par for similar work and experience. Yes, so this Right to Education Act and Right to Education rules and Article 21(a) does not envisage a contractual scheme of appointment. That is antithesis to the Act, the rule, and finally even 21(a). Because finally the Act and the rule is in aid of Article 21(a), imparting education, elementary education, universalization of it, and the nature of mandatory thing. Now, Lordship 21 rule is what is important, because as the heading says, you have to maintain a pupil-teacher ratio in each of the school for the purposes of section 25. Lordship 25(1), I'll just read. Sanction strength of teachers in a school shall be notified by the government, autonomous council, or local authority, as the case may be, within a period of 3 months from the appointed date. So, imparting education is not just opening schools. There has to be a teacher-pupil ratio. In order to comply with the teacher-pupil ratio, you appoint teachers. You are not supposed to appoint ad hoc, but you go ahead and appoint ad hoc. And you appoint and then you don't correct it. You then continue it endlessly. And that is our basic grievance. That this endless continuation of ad hocism is against Article 21(a), it's against Right to Education Act, and it's against the rules. And also it's against the law. We are now on Right to Education law. The law of the Supreme Court is the horrors of all of this. if you have taken service for so many years, you ought to regularize. And almost every case has directed regularization. Now, Lordship had asked, what is Lordship, I'm not relying on these two cases as precedent, but this is the only place where I could find what they talk about SSA is. There's one full judge bench of this court as well, but before that, Lordship, paragraph 7. This is some. Sorry.
Agartala judge.
Justice Qureshi's judgment. Agartala. I'm not referring to as a binding precedent. It's just that I found that there was analysis on
Yes.
SSA and the genesis of it. Paragraph 7.
Yes.
Even the government of India, realizing the importance of education in modern India and significance of education as an equalizing force in a diverse society with several disadvantaged groups, had initiated the steps for spread of education, which would cover the entire population, and for such purpose, Sarva Siksha Abhigyan, SSA for short, literally meaning Mission for Education for All, was undertaken in the year 2004. So it predates Right to Education Act. With the amendment of the Constitution formally giving the status of right to education as a fundamental right, followed by the enactment of RTE Act, this mission got further impetus. As we shall see thereafter, broadly, under the scheme, the Government of India would provide funds. Lordship, this is what SSA is. Government of India would provide funds and other assistance to state government to reinforce existing schools with best of facilities, to open new schools wherever necessary and justified, and to engage required number of teachers to meet with the new challenges and a sudden spurt of students who may be admitted in primary schools to fulfill the guarantee of free and compulsory education for children. The scheme also shows a paradigm shift for the merely achieving literacy rate targets to quality education to all, with a special focus on students of the vulnerable groups such as scheduled castes, scheduled tribes, minority, and women. Paragraph 8. These petitions are filed by those who were engaged as teachers in government schools under the SSA. They have formed an association of similar teachers and claim to espouse a large number of such similarly situated teachers, and so and so. And this is also for regularization. Lordship, I will not bother Lordship more with this. Then your Lordship, paragraph 22. Has paragraph 22? Mary?
Yes.
We may now refer to some documents which form a part of the pleadings and which will throw some light on the nature of duties and responsibilities and purpose of engagement of petitioners as SSA teachers. We are also all SSA teachers. In guidelines for implementation of restructuring and reorganization of the centrally sponsored scheme on teacher education. This is what I wanted to say. The system of engaging contract teacher was frowned upon, and reference was made to Section 3(3) of the RTE Act to ensure proper pay conditions of the teachers in order to impart quality education. There's a direct link to conditions of service to their performance. Comparison was made with other countries regarding pay structure of teachers in those countries. Following portion of this document may be noted. So this is the guidelines, Your Lordship, and this is a central guideline under SSA. Contract teachers, 2.12. Recruitment of contract teachers, that is, teachers whose pay and service conditions are substantially adverse vis-a-vis regular teachers, have been a matter of great concern and discussion in the recent past. Low salary, insecurity of tenure are features of system of appointment of contract teachers and are regarded as disincentives for talented persons to join the teaching profession. In government schools in 2007-8, 14.10% teachers were contract teachers. Their numbers being as high as 49.4 in Jharkhand, 38.8 in Uttar Pradesh, 34.4 in Jammu Kashmir, and 28.8 in Odisha. The state will probably be in a better position to say, I will also Google for the next time, what is our percentage. The right to education, section 23(3) provides the salary and service conditions of teachers would be as prescribed by the appropriate government. Given the anomalies that the system of contract teachers create in the teaching profession, and thereby on quality of teaching, the state would be well advised to prescribe uniform salary and service conditions for teachers, and also take steps to create an environment for attracting the most talented in teaching profession, improving recruitment policies, and exploring possibilities for improving career structures of teachers. Lordship, the next paragraph also is fascinating data, but I will not trouble your Lordship with it. 23, paragraph 23. Again, a government. Lordship, I'm relying on this
These
case.
are extracts of what?
Lordship,
Guideline.
this is the guideline. Lordship, it says, paragraph 23, Lordship, third line. The guidelines for implementation of restructuring and reorganization of centrally sponsored scheme on teacher education. Following portion of this document. Government of India document. Yes, Your Lordship, it's a Government of India document. Lordship, paragraph 23. In a letter dated 4/3/2013, Lordship, this goes back to 2013, and this guideline is contemporaneous, probably. In a letter dated 4/3/2013, the Under Secretary to the Government of India, written to the State Project Director of Punjab, it has been clarified that SSA provides support to new teachers in schools sanctioned under SSA and also additional teachers in existing school based on the enrollment. The support is given to the states for salary at the same scale and service condition as the teaching cadre of the state, and there is no separate SSA cadre of teachers. The following portion may be noted, and they're extracting this Government of India letter to Punjab explaining what is SSA. SSA provides support for new teachers in schools sanctioned under SSA and additional teachers in existing schools based on enrollment. The support to states for additional teacher and teacher salary is given at the same scale and service condition as of the teaching cadre of the state. There are no separate SSA scales or norms or rules for teacher recruitment. It is found that in Punjab, a separate SSA cadre of contractual teachers have been created, for whom service arrangements have been spelled out and they're posted only in SSA school. This is an erroneous phenomenon. All schools receiving SSA fundings are schools of the state government, and so are all the teachers. SSA is only a program providing additional funding to the state for elementary education, development, and reform. The state is advised to kindly desist from creating any anomalous situation on this account. 2013.
Yes.
Lordship, then the last paragraph of 2025, the last paragraph of the page. From page 1, 2 onwards, in so and so, the petitioners have produced several orders by different state governments regularizing the services of SSA teachers. These governments include state of Manipur, Sikkim, Himachal. So they've already regularized. Lordship, two more paragraphs
Who
because
has regularized?
sorry, Lordship.
Who has regularized?
state of Manipur, Sikkim, and Himachal Pradesh.
Where are they?
Lordship, that's a paragraph right before paragraph 11, page 11. Paragraph 25, second paragraph. Lordship, on the same page as I was reading. I was reading paragraph 23. This is paragraph 25, the second paragraph.
Yes.
The last paragraph from page 102 onwards, Lordship has that. The petitioners have produced several orders by different state governments regularizing the services of SSA teachers. These governments include those of state of Manipur, Sikkim, Himachal Pradesh, etc. So there perhaps were more. Now, Lordship, two more paragraphs. These are more my submissions which I'm adopting from this. Paragraph 39, Lordship, at page 18.
Yes.
May I read?
Please.
Paragraph 39. Before we go further, we may notice the provisions noted above not only refer to providing free and compulsory education, also refer to quality education, and which should be the duty and the responsibility of the appropriate government or the local authority as the case may be. The quality of education is thus inbuilt in the guarantee of free and compulsory education up to age of 14 years. The guarantee is manifest in the number of ways under RT Act and is not confined to a mere policy declaration of the legislature. The Act provides for admission of every child in a neighborhood school. It provides for levying no fees and charges which would prevent them from pursuing the education. It provides for creating infrastructure, including preparing number of trained teachers for imparting education. It requires that a student admitted should not drop out, etc. Then, Lordship, paragraph 42, the next page. This is on the role of teachers. Mary, if that be so, immediate question that would arise is, should the teacher who have a pivotal role to play in imparting such education and fulfilling the nation's obligation of free and compulsory education to every child can be kept on tender hooks for years together without proper salary and other service conditions which can guarantee at least a semblance of security. When a teacher is employed in school, has to play an important role not in formal education, in classroom teaching, but is expected to ensure proper atmosphere and suitable conditions where students belonging to vulnerable groups such as scheduled caste, scheduled tribe, minorities, girls, students are not forced to drop out before completing primary education. It is impossible to expect the teacher to perform such a role successfully if he or she needs the requirement of the most basic level are not satisfied. An unhappy teacher can never perform the task of motivating a child into completing education against all odds. To summarize, quality education is part and parcel of right to education, and a basic quality in education cannot be achieved without satisfying the basic needs of the person who is entrusted with this task. So this is where I say continuation of contractual employment is against Article 21A, it's against Right to Education Act, and it's against the rules.
Yes.
Now, Lordship, one more case of full bench, again, only on SSA. And in this case, of course, they direct regularization and they direct it in rem, Your Lordship. So it's a case where they don't only regularize those before them. The last paragraph says in rem, everybody similarly situated should actually get regularized. So and it's come much before any of those Supreme Court cases doing the same thing. Come. Lordship, this is a full bench judgment, and it's got to do with regularization of Shiksha Sarathis. So they're the helpers. And again, and the prayer was for absorption of these Shiksha Sarathis, as was done in Lordship. May I read paragraph 3? You'll
Yes.
Paragraph 3. This is 3-judge full bench judgment. these are the teachers' helpers under SSA. So they're not teachers, assistant teachers, they are Sarathis.
Yes.
Also, paragraph 3. Para 3. The prayer of the petition is, Lordship, I straight away read the prayer, which is the second paragraph. A direction to the respondents to formulate a scheme of absorption of the Shiksha Sarathis in any regular post or capacity under the state, as in the case of Shiksha Karmis in Assam, as well as similarly situated employees in Karnataka, Tamil Nadu, West Bengal, Tripura, and Arunachal. Lordship, paragraph 4 is what throws light on SSA again, and which is why I'm reading this. Paragraph 4.
Yeah.
Mary, facts relevant for adjudication of the case has been summed up by the learned single judge. For ready reference, relevant portion of the referral order dated so and so dealing with the facts may be extracted so. It would appear, I'm reading the quoted bit, Your Lordship. It would appear that the Government of India in the Ministry of Human Resource Development, Department of Elementary Education and Literacy introduced a program for universal education in India under the 9th 5-year plan with a nomenclature Sarva Shiksha Abhijan, SSA, through a time aiming to achieve a long cherished goal of universalization of elementary education, UE, through a time-bound integrated approach in partnership with states to change the face of the elementary education to all children in the age of 6 to 14 by years of age by 2010. So that was the original purpose. The objective of SSA is that all children must complete 5 years of primary schooling by 2007. All children must complete 8 years of schooling by 2010. Focusing emphasis on education for life must bridge all genders and social category groups in primary stage by 2007 and all elementary education level by 2010, as well as the universal retention by 2010. The statute mandates the financial resources and responsibility for implementation of the scheme, for which a sum of rupees 60,000 crore was estimated from the central budget and the state level departments for the next 10 years, which would be worked out after finalization of the district level elementary education plans. Now, what follows is important. The financial norms have been provided initially under the statute is to be shared by the central and the state government in 85 to 11%. So initially 85% by Government of India and 15% by state during the 9th year plan. Then 75-25 during the 10th and thereafter 50-50. So the funding is 50-50. It may have changed, which I don't know. So therefore there's a 50% funding that comes from Government of India, and it comes why? Because there's a constitutional mandate on the government of the nation to impart elementary education. The financial norms further provide that regarding sharing of costs, undertaking had to be taken from the state government. Similar principle has been laid down in the statute as regards support of teacher salary. Thus, the process under SSC, which started under the 9th year plan, is a continuous process and would carry on spontaneously. Lordship, this is what it is. And the ratio of this case, Your Lordship, is paragraph 17. Lordship, there was a case of division bench of Arup Kumar, which basically rejected the plea of regularization. Lordship finds that at paragraph 5. Then another single judge doubted that judgment and therefore referred it to a larger bench. And paragraph 17 is read with paragraph 5. It says, before we proceed to deal with the case on merit, we have thought it appropriate to deliberate on the referral order. We've already extracted paragraph 10 of the referral order. A careful analysis of the referral order as extracted above would indicate that the learned individual has taken a view that since the decision of Uma Devi, which was the basis of the decision of Arup Kumar Bhuiya, there has been much change in judicial thinking, as would be evident from the decision of Nihar Singh, thereby removing the very basis of the decision of Arup Kumar Bhuiya. And this calls for re-examination of Arup Kumar Bhuiya, for which the larger bench has been constituted. And finally, Lordship, last paragraph, they say that the state must they notice Upendas, and they said in light of Upendas, even a policy must be framed for regularization for even 6 such articles. And this is a full judgment, which notices SSA, its objective, the emphasis on quality of education being directly linked to service conditions of teachers. So, Lordship, this was SSA, right to education. And the fundamental obligation on the state to provide. And how that fundamental obligation to provide, as encapsulated in the Right to Education Act, requires a permanent, happy cadre of teachers, whose terms and conditions must be that, whose terms and conditions, not of salary, whose terms and conditions, other conditions of salary, pension, gratuity, etc., must be that of a regular teacher. That is the emphasis of the Assam rules. And the emphasis of Article 21A. 21A is the broad. Everything, the nitty-gritties are in the statutes. So that is 21A, Right to Education Act. Lordship, before I deal with all the case law on regularization, this was right to education. This case is unlike any other. There is an added constitutional mandate which requires the state to ensure that the conditions of teachers are such that it should always be akin to regular. So it is different from every other regularization case. This is a constitutional mandate and further fleshed out by statutory enactments. Lordship, one small thing, I'll take it out of the way. 2 cases, which are basically the lion and the lamb, because the Lordship said that we've agreed. There's an agreement, and we've agreed to terms and conditions which are now we are trying to challenge. We are challenging because there was an agreement.
You're not challenging.
No, we've not. No, we challenged and we withdrew.
You're not challenging the agreement.
No, we've not challenged it. No, we did challenge. We filed a writ petition, but we withdrew it. But the last, on 2025, that agreement that they wanted us to sign on initial payment, we came to your Lordship, and your Lordship was kind enough to protect us. So therefore, we are protected from that particular nature of agreement. Lordship, Central Inland, 1 paragraph. It has already been cited. But considering it, I think the major argument will be that we agreed. Lordship, I will trouble your Lordship and repeat the paragraphs. And this paragraph actually comes from a whole lot of analysis of English law from paragraph 83. But I'll trouble your Lordship only with paragraph 89. But it's not just any paragraph that just comes up in the air. It's an analysis of terms of contract and what are fair and what are not fair, and what your Lordship can, in your Lordship's discretion, strike out. Paragraph 89. Lordship, the discussion starts from paragraph 83. And it's all English law and United States law, but then finally they adopt that in paragraph 89. Lordship, it's page 215. Lordship, I'll read paragraph 88 also. Should I read paragraph 88? As
Yes.
seen above, apart from the judicial decisions, United States and United Kingdoms have statutorily recognized, at least in certain areas of law of contract, that there can be unreasonableness or lack of fairness, if one prefers that phase, in a contract or clause in a contract where there is an inequality of bargaining power between the parties, although arising out of circumstances not within their control or as a result of situation not of their own creation. Other legal systems also permit judicial review of a contractual transaction entered into in similar situations, circumstances. For example, so and so German law they quote, and the French. Now paragraph 89. So this paragraph has come after analysis of the international law. Should then our court not advance with time? Should they still continue to cling to outmoded concepts and outworn ideologies? Should we not adjust our thinking caps to match the fashion of the day? Should all jurisprudential development pass by us by leave us floundering in the sloughs of 19th century theories? Should the strong be permitted to push the weak to the wall? Should they be allowed to ride roughshod over the weak? Should the court sit back and watch supinely while the strong trample underfoot the rights of the weak? We have a constitution for our country, and that's important, Your Lordship. Our judges are bound by their oath to uphold the constitution and the laws. The constitution was enacted to secure that all citizens of this country social and economic justice. Article 14 of the constitution guarantees to all persons equality before law and equal protection of law. Now, what follows is important. The principle deducible from the above discussions on this part of the case is in consonance with the right and reason intended to secure social, economic justice and conforms to the mandate of great equality clause in Article 14. The principle is that the court will not enforce and will, when called upon to do so, strike down an unfair and unreasonable contract or an unfair and unreasonable clause in a contract entered into between parties who are not equal in bargaining power. It is difficult to give an exhaustive list of bargains of this type. No court can visualize the different situations which can arise in the affairs of men. One can only attempt to give some illustrations. For instance, the principle to apply where inequality of bargaining is the result of great disparity in the economic strength of the contracting parties. It's a creation of the parties or not. It will apply where the inequality is the result of circumstances, whether of the creation of the party or not. So even if I have gone and signed, is it my creation? But it's still an inequality in the result of circumstances. It will apply to situation in which the weaker party is in a position in which he can obtain goods and services or means of them. It will also apply where a man with no choice, or rather, that's the important thing. It will also apply where a man has no choice, or rather no meaningful choice, but to give assent to a contract or to sign on the dotted line in a prescribed or standard form, or to accept the state of rules as a part of the contract, however unfair, unreasonable, and unconscionable a clause in that contract or form or rule may be. And then it goes on further, Your Lordship, I will not. This paragraph 89, 88, and Lordship, this is reiterate in Bholana. And Lordship has been read, but because it's an important case, Lordship, I will trouble you again. Bholana. The 2026 judgment. It was cited by my learned friend, but I think it's worth repeating. Lordship, straight away to paragraph 11. Lordship, I will not read paragraph 11. That has already been read to you. State as a model employer. Lordship is aware of that. High probability, etc. Then Lordship, fundamental rights and their waiver. Because the argument is that you've signed. And Lordship, here also it says the appellant were appointed as respondent state against sanctioned post with the engagement being described from the inception as contractual. This is their argument, and this will be their argument, that you went in with your eyes open. The terms and conditions governing the engagement stipulated that the appointment would be an initial period of 1 year, extendable thereafter, subject to satisfactory performance. Lordship, in this case, it was part-time. It was not even full-time. The respondent accordingly attached this thing. Lordship, 11.6 is what is important. Lordship, 11.5 also I will read. The consistent case of the appellant has been that the respondent state's refusal to grant regularization is arbitrary and therefore warrants judicial interference. This is my submission also. Article 14 of the Constitution casts a negative obligation on the state to treat all persons equally, and arbitrariness being antithetical to equality principle is prescribed as violative of Article 14. The Constitution in Hasheshwarnath versus Commissioner of Income Tax long ago clarified that fundamental rights guaranteed under the Constitution are incapable of waiver. So Article 14 and to be treated equally cannot be waived. Consequently, if the action of the respondent state is found to be violative of Article 14 of the Constitution, the mere fact that the appellant's engagement was governed by contractual terms and conditions cannot be construed as a waiver of their fundamental right. Then Lordship, paragraph 12 cites inland, which I just read out, paragraph 89. And Lordship, I will straight away go to paragraph 12.1, last paragraph of 12.1, which is in the next page, page 12. Therefore, 12.1, Lordship, it starts relying, but it's Paniram. I will not bother your Lordship. It's already been read to you. But therefore is what, after noticing Paniram and Central Inland in 2026, this judgment, the Supreme Court says. Therefore, Lordship has, it is clear that courts are empowered to invalidate unconscionable elements of a contract where the parties lack the ability to exercise any real or meaningful choice in negotiating its terms. In the present case, the appellant were left with no alternative but to accept the conditions unilaterally prescribed by the respondent state in order to secure their livelihood and sustain a source of income. It would be entirely unrealistic to assume that in such circumstances, an employee seeking temporary employment would meaningfully engage or assert a position against the overwhelming might of the state machinery. 12.2. At this juncture, analogy of apples and oranges serve as a useful reminder that certain relationships are inherently incapable of being assessed on an equal plane. A contract between the state and the employee stands on a similar footing. The state in such a relationship assumes the role of a metaphorical lion, endowed with the overwhelming authority, resources, bargaining strength, where the employee who is yet an aspirant is reduced to the position of a metaphorical lamb, possessing the little real negotiating power. Suggest parity between the two, that is the lion and the lamb, would be to ignore the stark imbalance that defines the relationship. Therefore, when a lion contracts with a lamb, inequality is not incidental, but structural, and is precisely this disproportion that calls for judicial sensitivity. This is important, Your Lordship. Paragraph 12.3. In such situation, the conscience of the Constitutional Court must inevitably tilt in favor of protecting the lamb. We have no hesitation in holding that the contractual courts are duty-bound to act to safeguard those who are vulnerable to exploitation, so that employees are not compelled to meekly submit the demands of the vastly dominant contracting party like the state, but are instead assured that constitutional protection will intervene to prevent such exploitation. Lordship, I could not have said it better. So, Lordship, that takes care of the agreements and my position as a lamb. Now, Lordship, quickly, because I think all the cases have been already handed over, I'll made a note. I've extracted the I'll quickly go through. I'm not going to. Lordship will give you the compilation of the cases. Lordship, my first and foremost argument is contractual appointment of teachers is violative of Article 14 and Article 21A and violating of
list of cases.
Lordship.
The list of
No, I also extracted. I've extracted the paragraphs. The third page. Sorry, Lordship, we should have paginated it.
Madevi.
Sorry, I think it's our fault. We should have paginated it. It's the third page. Lordship, we hand paginated.
Nihal Singh.
No,
So these are
first page is
extracts of the various cases.
yes, Lordship. Uma Devi, I've extracted from Uma Devi because regularization begins from Uma Devi, Lordship. Now, Lordship, this is my argument that even if there was not, I'm not saying there is. I think my first argument is a constitutional argument. I'm on a situation where there is no constitutional guarantee like these cases. If a state takes services for a prolonged period of time, then it is incumbent on the state to regularize. That is the law of the land. And that has been the law of the land since 2006, no matter what anybody has to say about Uma Devi. Because that is what the Supreme Court has explained Uma Devi to me. Because the state goes on. And there are paragraphs in Supreme Court cases where they say the state relies on Uma Devi. And they say that is absolutely wrong. And I will quickly, Lordship, not even read all of the things. There's Uma Devi, your Lordship has it. There's ML Kesri. Lordship, I will only read the highlighted portions. ML Kesri, Lordship, the last paragraph 11. Lordship, just so that we get the trend of where what the states typically do, and therefore what the courts are doing. Paragraph 11. The object behind the said direction in paragraph 53 of Uma Devi is twofold. First, to ensure that those who have put in more than 10 years of continuous service without protection of any interim order or courts, tribunal, before the date of Uma Devi render are considered for regularization in view of their long service. That's number one. Number two is important. It is to ensure the department instrumentalities do not perpetuate the practice of employing persons on daily wage, ad hoc contractual basis for long terms. The state should have from 2006 stopped. If they are so determined to say that we are bound by Uma Devi, then Uma Devi required them to stop ad hocism and start from 2006 onwards. They have not done that. We were appointed ad hoc in 2012. 5 years, 6 years after Uma Devi. Lordship, this is not regularization. This is the Right to Education Act. Basically, paragraph 233, which basically says that you don't have money is not an answer to a constitutional mandate. 21A requires the state, Lordship, I've quoted all the paragraphs. I will read only 233. The state has necessarily to meet all expenses of education of children of the age 6 to 14 years, which is the constitutional obligation under 21A of the Constitution. Therefore, the state to come and say we don't have money is not an answer in the context of teachers. Then your Lordship, Nihal Singh. Lordship, I'm sorry, I should have paginated. Nihal Singh. Lordship, I will read paragraph 23 straight away. Even by going by the principles laid down in Uma Devi, we are of the opinion that the state of Punjab cannot be heard to say that appellants are not entitled to be absorbed into the services of the state on permanent basis, as their appointments were purely temporary and not against any sanctioned post. So we are better off there are sanctioned posts. In our opinion, the initial appointment of the appellants can never be categorized as irregular appointment. The initial appointment of the appellant is made in accordance with statutory procedure contemplated under the Act. And I've shown your Lordship, advertisement also say that we've also been appointed as per the rules and the Right to Education Act. The decision to resort to such a procedure was taken at the highest level of the state by conscious choice, as already noticed by us. Lordship, next page, paragraph 37. Lordship, these have been read, so I'm not rereading. I've just highlighted everything. Paragraph 37. We are of the opinion that neither the government of Punjab nor these public sector banks can continue such a practice consistent with their obligation to function in accordance with the Constitution. Uma Devi judgment cannot become a license for exploitation by the state and its instrumentalities. Paragraph 39. This is the result, your Lordship. We direct the state of Punjab to regularize services of the appellant by creating necessary posts within the period of 3 months. Upon such regularization, the appellant would be entitled to all the benefits of services attached to the post, which are similar in nature already in the cadre of the police services. So this is what Supreme Court has been doing. Next, your Lordship, Jagdeep Singh. I will not bother your Lordship. It's basically equal pay for equal work. So just because you're temporary doesn't mean you're doing us a favor by paying the same thing. Then your Lordship, Narendra Kumar Tiwari. I will not read this. This is for Lordship already knows equal pay, equal work. And even if it's temporary, it doesn't take away that. Narendra Kumar Tiwari, your Lordship, this is an important judgment. Paragraph 5, may I read, your Lordship?
Yes.
The decision in Uma Devi was intended to put a full stop. Okay, sorry. The decision in Uma Devi was intended to put a full stop to the somewhat pernicious practice of irregularly and illegally appointing daily wage workers and continuing them indefinitely. This was Uma Devi, which they rely on. In fact, in paragraph 49 of the report, it was pointed out that rule of law requires appointment to be made in a constitutional manner, and the state cannot be permitted to perpetuate an irregularity in the matter of public employment, which would adversely affect those who could be employed in terms of the constitutional scheme. It is for this reason that the concept of one-time measure and the cutoff date was introduced in the hope and expectation that the state would cease and desist from making irregular or illegal appointments on regular basis. The purpose and intent of Uma Devi was therefore twofold, namely prevent irregular and illegal appointments in the future, secondly to confer a benefit of those who have been irregularly appointed. Then, Your Lordship, the fact that the state of Jharkhand continued with irregular appointment for almost a decade after Uma Devi is a clear indication that it believes that it was all right to continue with irregular appointments. That is exactly and precisely our case too. And whenever required, terminate the services of the irregularly appointed employees on the ground that they were irregularly appointed. This is nothing but a form of exploitation of employees by not giving them the benefit of regularization and placing the sword of democracy over the head. I rely heavily on this. Lordship, next, Shivnarayan. And Lordship, I've put it chronologically.
Yes.
It's not that suddenly 25-26, the Supreme Court has woken up to regularization. This has been since 2000, ML case 2017. Lordship, I will read only the underlined portions. 209, paragraph 7. I'll straight away go to the underlined bit. We regretfully make the observation that Uma Devi has not been implemented in its true spirit and has not been followed in pith and substance. It is being used as a tool for not regularizing the services of incumbents. They are being continued in service without payment of due salary, which they are entitled on the basis of Article 14, 16, read with Article 34, 1D of the Constitution. As if they have no constitutional protection as envisaged in Diaz Nascara from cradle to grave. In heydays of life, they are serving on exploitative terms with no guarantee of livelihood to be continued, and in old age, they are going to be destituted, there being no provision for pension and retirement benefits. There is clear contravention of constitutional provision and aspirations of the downtrodden classes. They do not have equal rights, and to make them equal, they would require protection and cannot be dealt with arbitrarily. The kind of treatment meted out is not only bad, but is equally unconstitutional and is denial of right. We have to strike a balance to really implement the ideology of Uma Devi. Thus, the time has come to stop the situation where Uma Devi can be permitted to be flouted, whereas this court has interdicted such employment way back in 2006. The employment cannot be on exploitative terms. Whereas Uma Devi laid down that there should be no backdoor entry, every post should be filled by regular employments, but a new device has been adopted. I rely on this. A new device has been adopted for making employment on payment of poultry systems on contract, ad hoc basis or otherwise. This kind of action is not permissible when we consider the pith and substance of the true spirit of Uma Devi. And even in this case, Lordship, paragraph 9, the bold, the services of the appellant has been regularized with effect from the date of appointment 2002. Consequential benefits and areas of pays to be paid within the periods. Consequential benefits. So every case of regularization is not piecemeal. Supreme Court has regularized from the date of appointment. Lordship, Central Administrative, this is just central judgment. It says exactly the same thing. I will not bother your Lordship. Prem Singh, Lordship knows. It talks about pension and regularization. Vinod Kumar has been relied on. Paragraph 5, Lordship, underlined portions. Lordship has paragraph 5 of the essence of employment and rights thereof cannot be merely determined by the initial term of employment when actual course of employment has evolved significantly. And Lordship, paragraph 7 says, if you are appointed through a procedure which mirrors a regular procedure, which is basically written examination or interviews, you can then turn around and say that has been illegal. And paragraph 8, the last 3 lines, the failure to recognize the substantive nature of their roles and their continuous service akin to permanent employees runs counter to the principles of equity, fairness, and intent behind employment regulation. These are said not even in the context of teachers and Article 21A. Lordship, Jaggu was again read. Lordship, I'm not going to read again because you've seen prolonged, this is what it is, prolonged, continuous, unblemished service performing tasks inherently required on regular basis can over time transform to what was initially ad hoc or temporary to a scenario demanding fair regularization. This is it. Dehors, Article 21, right? Even if I was otherwise, Jaggu, relying on all the cases before, says prolonged, continuous, unblemished service performing tasks inherently required on regular basis. I am there to fulfill their teacher-pupil ratio. Over time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. And Lordship, this is concerning Lordship, paragraph 25. Paragraph 25, the last bullet. Lordship, this has been read over to you, so I will not. Of Jaggu, paragraph 25, the last bullet. Denial of basic rights and benefits. My learned friend has already read about temporary labels, arbitrary termination, lack of career progression, which is seniority. And they say that impacts you. But this is important. Denial of basic rights and benefits. Temporary employees are often denied fundamental benefits. They call it fundamental, Your Lordship. As pensions, provident funds, health insurance, paid leave, even when their tenure spans decades. This is exactly what has happened to us. For the last 15 plus years, we've been denied pensions, provident funds, health insurance, paid leave, everything. This lack of social security subjects them and their families to undue hardship, especially in cases of illness, retirement, or unseen circumstances. And Lordship, this is not disconnected from reality. This is the reality. And which Supreme Court has taken judicial notice of. Paragraph 26. When the judgment in Uma Devi sought to curtail the practice of black door entries and ensure appointments adhere to constitutional principles, it is regrettable that its principles are often misinterpreted or misimplied to deny legitimate claims of long service employees. I'll jump again to the bold and the highlight, the underline. However, laudable intent of the judgment is being subverted when institutions rely on its diktat to indiscriminately reject the claims of employees, even in cases where their employments were not illegal, but merely lack adherence to procedural formalities. Government departments often cite, this is what I'm relying on, government departments often cite judgment in Uma Devi to argue no vested right of regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. I heavily rely on this. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable services over decades. In the light of these considerations, in our opinion, it's imperative for the government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended period, especially when their roles are integral to organizational functioning, not only contravenes international labor standard, but also exposes organization to legal challenges and undermines legal morality. Lordship, then comes Dharam Singh.
Yes.
Paragraph 17, Your Lordship.
Very well. We have gone through the judgment.
Yes. Lordship, just to show that at the end of it, they're all, Lordship, paragraph 18. This is important. Dharam Singh.
Yes.
Paragraph 18. Moreover, Mary,
Yes.
it must necessarily be noted that ad hocism thrives when administration is opaque. This is judicial recognition of what is happening. I cannot argue more than this. the state departments must keep and produce accurate establishment, muster rolls, outsourcing arrangements. And they must explain with evidence why they prefer precarious arrangements over sanctioned posts when the work is perennial. If constraint, quote unquote, is invoked, records should show what alternatives were considered, why similarly placed workers were treated differently, and how the chosen course aligns Article 14, 16, 21. Sensitivity to human conditions for prolonged insecurity is not a sentimentality. It's a constitutional discipline that should inform every decision affecting those who keep public offices running. Lordship, I don't think the Supreme Court can be stronger than this. Finally, Your Lordship, and Lordship, Dharam Singh is very important because Dharam Singh says, and this is not Right to Education Act, it is DHORS, it's on regular work charge employee. It says, don't come and tell me, Dharam Singh says the state can't come and say there is no.
According to you are on a better foot.
I'm on a better footing because of Article 21 and Right to Education. But even if I weren't, all of this, Lordship, I'm on retired appellants. Any appellant who have already retired shall be granted regularization with effect on appointment date until the date of supervision. So they've gone to that kind of detail, Lordship. In my note, I have highlighted wherever there has been from when. So Supreme Court has not just said frame. High courts have done it. Supreme Court has not said that. And in fact, Dharam Singh actually says, give me a compliance affidavit. This is how strongly they have come up with. And it says, as a constitutional employer, you are held on a higher standard. And Lordship, the last line is really. Yes, Your Lordship, yes. It's cited somewhere, which is why I didn't cite it again. I was like, I would get tired of reading. Lordship, last paragraph of paragraph 20 is important. And this is what I emphasize. Because the state must know what its role is. The state comes as though increasingly the state comes to state that might is right. And the state must reconsider that argument. In fact, this is not a matter which require litigation. As a constitutional employer, the state should have taken a decision that if I pay on initial pay, it violates the constitution. It is an ignorant decision. The decision not based on the knowledge of the constitution. And that is what Supreme Court says. The operative scheme we have set here comprising of creations of superannuary posts. So they've said you create posts if you don't have it. Full regularization. Subsequent financial benefits and a sworn affidavit of compliance is therefore a pathway designed to convert rights into outcomes and to reaffirm that fairness in engagement and transparency in administration are not matter of grace, but obligations under 14, 16, and 21. The state thinks they're doing us a favor by giving us 17,000 instead of 45,000. And they will argue that. They will argue that with a straight face and a constitution in their hand.
All right.
Lordship, last case, because this was not cited. Sukhvendu Bhattacharjee. This is Upen Das. This went to Supreme Court and Supreme
is with regard to regularization of master role.
Yeah, master role. And it basically said that you have to regularize. And this is the reason I've put it is because it's in the context of Assam and Lordship. It relies paragraph 2, then 31, 31.6, Your Lordship. 31.6, 7, Your Lordship. Pension being a valuable right and a facet of socio-economic justice in a welfare state, denial of such benefit after decades of continuous service is arbitrary, unjust, constitutionally impermissible. So they're not doing us a favor if they give us pension. And they think they can get away by taking our work in compliance. They say in compliance with the Right to Education Act. And then they turn around and say, no, pension we will not give. We will regularize you. We'll give you everything. It's not a matter of grace. It's a matter of a constitutional obligation. And what they're doing is constitutionally impermissible. Again, this obligation flows directly from the Constitution and is not discretionary. I can't argue more. Yes, practice of retaining employees for decades under deceptively titled designation while simultaneously extracting regular work integrity has been disapproved consistently. I can't argue better than Supreme Court decision. So Lordship, that is my case. So I'm asking for regularization on the ground that the law.
Just a minute. Yes.
Lordship. So my first submission was it's a constitutional mandate to treat teachers, even contractual, as regular in terms of the right, the rules, not just salary, but all other benefits as regular. This thing. There was no concept of
We have
S.
taken note of
Yes.
that.
Obliged, Your Lordship. Obliged.
Yes. But items,
Two. I'm three. Sorry, Lordship.
item 3,
Three.
6, 3 and 6.
I'll add up my opinion.
What are your case numbers?
My case numbers is
Item numbers
5, 6, 10, 11, 17,
5,
19,
6, 10, 11, 17,
19, 24, 26.
19, 24, 26.
26. But
One
just,
by one, one by one.
just what I wanted to add that the petitioners were appointed in 2012 because of a mandate of the RTA. It says that within 3 years of the constitution in 2009, they have to appoint regular teacher. Lordship, if Lordship reads, I'll just place for one moment the RTA Act for once. Section 18. And 19.
18.
18, section 18, 19, 26. Well,
Read,
then
read.
26.
Read.
No school other than a school established, owned, or controlled by an appropriate government or the local authority shall, after the commencement of this act, be established or function without obtaining a certificate of recognition from such authority by making an application in such form and manner as may be prescribed. The authority shall issue the certificate of recognition in such form, within such period, in such manner, and subject to such condition as may be prescribed. From
this school.
yes, Rachib, I'll come down to 19 then.
19.
19. On contravention of 3, on contravention of condition of recognition, the prescribed authority shall, by order in writing, withdraw the recognition. Therefore, thereafter, I'll come to 19. Norms and standards for school. No school shall be established or recognized under Section 18 unless it fulfills the norms and standards specified in the schedule. Schedule, Lordship, I will place. Where a school established before the commencement of the act does not fulfill the norms and standards specified in the act or schedule, it shall take steps to fulfill such norms and standards as its own expenses within a period of 3 years from the date of such commencement. Where a school fails to fulfill the norms and standards within the period specified under subsection 2, the authority prescribed under subsection 1 shall withdraw the recognition to such school in the manner specified under section.
Where does it mention regular teachers?
Yes, Lord. Now, if Lordship sees Rule 18 of the rules, Lordship have already seen, it says that to create a professional cadre.
That has already been argued.
Yes, Lordship.
In addition
Therefore,
to that, is there anything
if
more
Lordship
you want
sees
to
the
say?
schedule for a
We've
moment,
seen it. Schedule does not reflects the number of teachers.
number of teachers, Lordship, coupled with the fact that it says that it has to be a every norms, pension, gratuity, everything
Wait,
like
wait.
a regular teacher.
Wait.
Lordship, rules 241 of this book
State rules.
State rules.
Yes.
Yes, Lordship. Rule 18, 23 for a moment.
23.
18. The government autonomous council salary and allowances and conditions of service and of teachers for the purpose of section 23(3). The government autonomous council or local authority, as the case may be, shall notify terms and condition of service and salary and allowances in order to create a professional and permanent cadre of teachers.
You are a permanent cadre, but cadre in the contractual teacher.
Lordship,
It's a permanent cadre.
the mandate of law. Lastly, the mandate of law requires us to be appointed under section 3 of 1977 rules. We have got a definite selection process by an advertisement, by a concrete selection process. Lastly, Lordship, I'll just place the 1981 rules for a moment, which says that if we are appointed under section 3 and we continue for 3 years, we are destined to be confirmed.
What 1981 rules?
1981 rules.
What rules are they?
Yes. I have specifically pleaded in my petitions also. One second. It's the Assam Elementary Education Provincialization Service and Conduct Rules 1981, 310 of this book, Green Book. Lordship, 310, the definition of service. Service means the service rendered under the State Board for Elementary Education constituted under the Assam Elementary Education Act 1968 and the service rendered under the government before or after provincialization, but in respect of teachers other than employees.
How is this relevant?
Lordship, it says that for confirmation, if I continue for 3 years,
Firstly, does it apply to you? Was this recruitment under this particular rules?
no, it was contractual in nature.
How are you referring to you? For state board for elementary education.
The definition of service says that any service under the state government.
Any service under the government will mean a government service. You're not into government service. You want to be regularized now. Your entry is not into government service. Yeah, that's it. Yeah. Submit. Right in this one. Service and contact rule 1981. Services of the contractual teachers are rendered under the government as per the definition of well, What else?
And secondly, as already argued, Project, that the Act and the rules emphasizes a permanent cadre.
Act and the rules. The Act and the rules state these are permanent cadre, professional and permanent cadre. Therefore,
And if it is not done, the recognition may be withdrawn or cancelled by them.
and if such mandate or not, then the Act and
If
I appear on behalf of Team York. Lordship, we also adopt the
which
arguments.
items?
Item 20.
Item 20, so and so submits that she adopts the argument made by Chief. 13 and 20. 13 and 23. So and so adopts the argument of
Item 18, item 8 and 29, we are adopting the arguments of Mr. I. Chaudhary.
item.
Item,
Mr.
Item
Rajkumar, council appearing for item numbers
item number 18,
18,
8 and 29, I am appearing for Mr. L. Bothakur.
8 and 29. Adopts the argument made by Mr. Raj.
Based one judgment of the division bench of Tripura, Your Honor.
That we
And,
have Justice Qureshi's judgment.
yes, sir. Okay,
It's already happened.
Actually, I'm appearing on item number 25, Lordship. Adopting the arguments made by the senior counsel.
Which senior counsel?
I Chaudhary,
Item 25.
25.
Counsel.
Okay.
I'm adhering in item number 4, 12, 27 and 28.
Item number
4, 12, 27 and 28. I am
7 and 28.
but in support to the arguments already made by senior counsel Mr. I. Chaudhary and I'd like to place one point, Miller, here, is that the rules, Lordship have already seen that it provides for creation of a permanent cadre. And these rules, my lord, the state rules itself provides for relaxation of the rules. Well, whether the state can invoke the relaxation of power to deprive the persons from by keeping them as contractual basis. My respectful submission to that, my lord. If your lordship kindly come 29 of the state rules, my lord. Rule 29, lordship has got it, my lord. May I read, madam? Power of governor to dispense with or relax the rules. Lordship has already read the rule 18, where it says, my lord, it has to be professional cadre, permanent cadre, all salaries and all these things, my lord. Whether that by exercising this rule, the state can dispense with their requirements, my lord. My respectful submission will be no, my lord, because
So is there any invocation of this power? in the
then
first place?
that will be their argument, my lord. Because
How do you know? They've not even
even if it is argued, my lord, that they are what I am saying, even if it is argued that by invoking Rule 29, they cannot do so, my lord, because the scheme itself, my lord, and in addition to that, my lord, lordship had a query regarding the project approval board. In petition, my lord, I have annexed two recommendations of the PAB. And what is the role of the PAB, lordship, the query? It is a board, my lord, not a statutory board, but in compliance of section 7 of the Act, Principal Act, my lord. All the funds are rooted on the approval of the PAB, my lord.
Section 7 says sharing of financial and other responsibilities. If your lordship takes up the petition, my lord, item number 4. I have annexed minutes of PAB meeting. Lordship, kindly turn to page 114. It starts minutes of 196 PAB meeting. Your lordship turns to page 125. Nine point 3.1.
Yes.
The state has different appointing authority and procedure for selection of teachers for teachers proposition born on state budget and the SSA. The state budget teachers are appointed by the Directorate of Elementary Education Assam and teachers appointed by the state project director. PAB advised the state to address the issue as this will create problem in their redeployment in the schools and advised that all the teachers should be recruited by the state government even if SSA is paying for teachers posts created under the program. Next, PAB minutes, lordship will find at page 133. Relevant portion at page 141. Down below, my lord, 9.3.1. Lordship has got it, my lord. PAB expressed concern over large number of vacancies and advised the state to fill up the vacancies born on state budget first. Funds for new recruitment under SSA would be approved only when all the state vacancies are filled up. PAB also advised the state to do away with the dual cadre for teachers as all the teachers belong to state. The state was also asked to comply with the commitment it has given and so and so.
Already referred to.
My lord?
This was already referred to
Yes,
in the earlier argument.
Yes, but pursuant to this, my lord. In fact, my lord, the project approval board, which is headed by the union secretary, and it has members of Niti Aayog and other persons, but they have consistently recommended the state government for making one cadre, my lord.
All right. You are relying on the argument made by
Both my I Chaudhary and G. Goswami.
you are relying on the submissions of Mr. Rai Chaudhary.
I Chaudhary and G. Goswami.
You are appearing in which item?
Item number, my lord, 4, 12, 27, and 28.
Items 4, 12, 27, and
28.
28. Chakraborty adopts the argument made by Mr. Rai Chaudhary. He refers to, in addition to that, he refers to keep state rules 2011 submit that government is to create a professional and permanent cadre of teachers. So, power of relaxation under Rule 29 for the government, same cannot be resorted to mandate. Requirement of the rules to create a permanent cadre.
Yes.
Which, in other words, has to be a state cadre.
Yes. And as regards, my lord,
Further refers to the PAV meeting, minutes of the PAV meeting. Submit that time and again. The minutes reflects that the recruitment are to be done by the state, as is referred to in minutes of the meeting held on 18/3/7, WPC number 1879 of 2019, as also at 9.3.1, as also the minutes of the meeting held on 1st of May 2014 at 9.3.1.
As regard background of enactment of the act, my lord, the in paragraph 9 to 20, it has been stated in the petition. My lordship will refer. Obliged.
Yes, all the petitioners, any more of the petitioners? Yes,
the state side, my lord, Kanan easy will this will also. It is minimum take about 7.
bench is not available. Earliest we can give you is 8, 10. Fix it on 8.
8, my lord, then.
The counsel for the petitioner with their argument fixed on 8th of September. Reply by the state.
My lord, there are interim orders in some of the items.
Interim orders wherever passed will continue.
Okay.
Yes.
This is a petition I filed for correction of a typographical error, my lordship. And
Where is it?
my lordship may be pleased to peruse page number 13, paragraph number 4,
Paragraph
4, my lordship.
yes.
Yes, my lordship, in the paragraph number 4, may I read the paragraph? Yes,
The point out
Yes,
the correction.
yes, my lordship, the correction, then in fourth paragraph, my lordship, the sixth line, the first word, sixth line, it should have been maths instead of science, my lordship.
That is, thereby the petitioner son obtained the passing marks in
In mathematics, my lordship, instead of science, my lordship. But failed in
mathematics.
science. It should mathematics. Then
Instead of mathematics, instead of science, it should be maths.
Maths, my lordship.
And instead of maths, it should be science.
Then, my lordship, in the next subsequent line, my lordship, it is been given that according to the learned counsel for the petitioner's son had already been awarded. This one, my lordship, had not been awarded. It should have been not. Instead of already, it should have been not been awarded. 2 grace marks.
The 2 grace marks were awarded.
This is their submission. Our submission was that grace marks was not added, my lordship.
No, there were 2 grace marks added in maths.
My lordship.
That is what we had recorded.
No,
Their submission was,
my lordship, may
and now this,
my lordship might remember the honorable the earlier litigation, my lordship, the grace mark was not added, my lordship.
Time.
For science, my lordship.
Yeah.
Grace mark was
Because they said that we have added grace marks in maths.
yes, my lordship, because since this paragraph includes the submission on the side of the petitioner, my lordship. This paragraph is paragraph number 4 is a submission from my side, from petitioner.
the submission of the petition. This is not the typographical error.
My
This will
lordship.
change the picture of the entire case.
And my lordship may kindly see, my lordship has written already not, then again, my lordship, the word mathematics already been awarded 2 grace marks in mathematics, subject thereby enabling the petitioner to secure passing marks in that subject. That was not my submission, that was their submission, my lordship.
My submission is written.
Their submission is written, my lordship. This is my submission, my lordship. Actually, this paragraph is my submission, my lordship.
Now they want to
And-
change their submission.
My lord-
Where-
my lordship, may I be
point out
permitted to
one-
submit, my lordship? And my lordship, the last line also, then my lordship, if which was complied with the respondent authorities by awarding the applicable grace mark in that subject, by not awarding, my lordship.
Recall that order in person threshold.
Yes,
My
my lord,
lordship.
you have initiated, my lord, a review petition. Why, my lord? Because of this submission, my lord, you have made an observation that
You have filed a review
so, my lord,
against against this order.
my lord,
Let it be listed to me.
my lord. Because, my lord,
When are you filing it?
my lord,
Initiated.
or will get the number.
Right, let it come
Yes, my lordship.
Next
That,
week.
yes, my lordship.
for first week of September.
No, my lordship, because of this, I will, my lordship.
Right,
next
matter be listed next week, along with the review petition, which is stated to,
CPS.
along with the review petition, we filed by the respondents.
My lord. Because, my lord, like the order, not that document they have annexed, my lord, not put some.
We'll examine it.
My
with the
lord.
review.
Yes, my lordship, my lordship.
Pointing it out.
Because this paragraph
Take the order.
includes my submission and this was not,
Matter be listed
Yes.
next week.
my lordship, may
We
I?
are not saying anything because you have not filed your review.
Yes,
My lord.
So you file it and make a mention and get it listed together.
Yes, my,
We are merely saying the matters will be listed next week.
my lordship, my lord.
Deeply.
Obliged.
File the state petition against the order passed by the tribunal. By which petitioner submit for regularization. So it is in the context, it is written that affidavit has not been filed by
Item number 35.
35.
Item number 35. Is not said fact that is
In item 36, we have challenged the tribunal for that.
item
No,
number
the reply file.
In item 35, your lordship pleadings are complete.
36.
36, your lordship, this is the subsequent order I have. No, in item 36, pleadings are complete. And item 35, your lordship, this is the subsequent order issued passed by the department which we have challenged. But
What are you challenging in 36?
36, after the passing of the tribunal's order, your lordship, there are some
order has been passed by the department regarding my service, which we have challenged in the item 35. Is that repetition, Your Lordship, final respondent?
Madam,
Regarding 35.
Huh?
We have not now filed our affidavit.
you don't want to file?
We are going to file some time.
Your Lordship,
26 and 25 minutes.
Your
That
Lordship,
is not the ground.
very ample
You
time
file it within 2 weeks. No, 2 weeks.
In that case, Your Lordship, petitioner is going to retire very soon.
When?
In the month of September.
September.
2027.
27. Very nice.
A date may
The
kindly
matter be listed after 2 weeks, enabling the state council to file their reply affidavit.
a date-
Sorry, affidavit in opposition.
a date may kindly.
9th September.
Okay.
Council and council got annual enterprise.
Sorry?
And council got annual. We have indicated the opposing party.
Limitation.
Yes,
That matter.
that was the point. Like it was they fixed in order for their reply. Let's suppose
He was unwell
he was present, but
after sitting in the court.
Yes.
In this
We
court.
got fever, yeah.
He got unwell sitting in this court.
Yes.
Convey our apologies. Matter be listed again after
on 21st or
21st.
not on 21st. It has to go to September.
he had to reply only on that point. Otherwise, you know,
Bench is not available. September. As they submitted the respondent counsel, arguing counsel to the respondent. Well. Okay.
Can they take up item 39 first? 39. Regarding the instant batch of petitions, I'm being told that the state government is deliberating the issue along with the homeopathic council. And a particular decision, some of developments are going on regarding that. And a particular decision will be reached into. Person may take this matter after 2 weeks, 3 weeks. We'll give an update regarding.
What has happened is, based on the interim order provided by the court, I continued with my internship. That's the last leg of my entire course. Now, 2 of the petitioners from out of 5 in item number 39, 2 have completed the internships. Now, they want their final passing out certificate so that they can apply for jobs. Good jobs opportunities are also coming up. One, I have already missed the bus, which is coming up next Monday.
No. What is your grievance now? What has happened?
Grievance is that the 4th year examination, which I cleared, that was held to be null and void because I did not maintain a gap of 6 months between my 3rd year examinations and my 4th year examination.
Which according to you happened because of the fault of
the
the
university. Now, the university filed their affidavit. Their affidavit, they say that whatever the council will say will depend on whatever the council
Rules for the
advises.
council. What do you say?
We are the regulatory body. They are the main India logic.
What according to you is under your regulations?
Yes, Lordship, there must be a 6-month gap between.
That is all right, but the university says that yes, it is their fault.
Yeah.
So what are you going to do now?
If they have university approach the council, then
can be
Huh?
certain decision maybe
Why can't the council give a decision to the court when the matter is before the court? Why do you want the matter to be sent back to the council? Get your instructions next week.
My lord, they have placed their stand by way of an appeal. The spirit of their stand is, my lord, that proper classes and proper class is required because this is a medical course. Now, while not maintaining the 6 months period, you are obviously not attending proper classes. Now, for fourth year, it runs to about 1.5 years of time for the entire fourth year. Now they say that you have not conducted the classes, you have not attended the classes because there is not 6 months gap.
So explain to us what
Yes.
is the 6 month.
That for that, my lord, I'll just place a chart which I have made based on my affidavit. Now, what we are concerned with is the third year, or you will see the second last column for supplementary examination third year. That was held in July 2024, and the result of the supplementary examination, that means the back examinations, my lord, that was declared on 14/11/2024. Now, from 14/11/2024, lordship will currently come to the fourth year regular examination date, April 2025. So 6 months, as per the regulation, you have not given a gap of 6 months. Now they come up, the commission comes up, they say that you have to do all of your classes and training and everything. So that is the
So till 14/11/24, you could not attend the fourth year classes.
from 14/11. No, I did actually.
How?
That is my case. Now your lordship would kindly come to the fourth year admissions. 16/10/2023. That is the time immediately after the third year regular examination, September 2020.
Even if you have a back.
Even if I have a back, just like the law examinations, man. So the moment I clear my regular examination in the third year, I take admission on October. Then in the midst of the entire course, till the fourth year final examinations, which is held in April 25, I give my back examination, that is a supplementary examination, and the result comes out. So they're considering the time period from the result of the supplementary examinations till the regular examination of fourth. But if we consider the time,
what is the evidence that you attended classes from 16/10/20?
they do not dispute, my lord, and let the university produce the records that I have not taken admission.
Taking admission is different, attending classes is
I have done so, my lord, because why I'll submit, my lord? Because the moment I was allowed to sit in the fourth year final examinations is because I have the minimum attendance, my lord, that is 75%. So I qualified in the minimum attendance, 75%.
Under what provision is the person allowed to take admission if there is a all the subjects are not cleared? What will your regulation rule say?
My lord, you kindly come to page 96. Facility to keep term after repetition. Page 96. Facility to keep term. Number Roman 3, my lord.
Roman 3.
Facility to keep term. Notwithstanding with the foregoing regulation, the student shall be allowed the facility to keep term on the following conditions. The candidate must pass the second BHMS examination at least one term, 6 months before he is allowed to appear in the third. The candidate must pass the third BHMS at least one term, 6 months before he is allowed to appear in the fourth. The candidate shall pass first BHMS in all the subjects at least one term, 6 months before he is allowed to appear in the second BHMS examination, provided that he has passed in the subjects of anatomy and physiology. Examination 2 terms before he is allowed to appear in the second. So this continues, man. So they allow us to take admissions. Even if in our law course, my lord, the same thing is done. once I appear in the subsequent year examination, I'm allowed to sit for my back examination.
But these law regulations don't govern the homeopathy.
And there is a relaxation clause which the commission say now is because if we impose it, the relaxation clause is at page 99, Roman 14 Roman 3, clause 14 Roman 3, page 99. They say if we impose this power of to relax, tomorrow across India, everyone will come and seek that particular.
Rightly, relaxation is not en masse.
So here,
it's always on a case-to-case basis.
Here, as per the 6 months gap,
You get a certificate, place it before the court that you have attended classes. Get the certificate from the college, university.
Adversarial litigation is going on. The principal is no way going to give us all those documents, and let them revert. Let them revert that I have.
Yes, who's for the university? You were there.
Yes.
So what do you say regarding this claim? He has attended classes. Give us a clear answer in affirmative or negative. Yes, he attended classes. No, he did not attend classes.
That I will.
By consulting your records. Third, counsel for the parties. Mr. Dole. Want to submit?
Lordship, regulation 11, Lordship 5, not only classes, Lordship, special classes, seminar, demonstration, practical, tutorial, all are. Lordship,
The
classes attended,
third counsel for the party, Mr. M. Mia, counsel appearing for the health department. You attended classes where?
That is Sohit Jadavnath Homeopathic Medical College. The respondent 7.
Who appears for 7?
Learned friend appears.
I'll only be able.
The counsel appearing for the health department is also 7 will place before the court by way of an affidavit. The petitioner facts as to whether the petitioner had attended classes and all the necessary seminars, demonstrations, practicals, etc. mandated under 7, 5, and 5. Pursuant to his admission in the 4th year, stated to have been undertaken on 16/10/2023, extending that there are certain subjects which the petitioner for certain, how many papers? Certain papers which pertaining to the 3rd year, which the petitioner had failed to clear and which he ultimately cleared 11/20. And this information will be placed before the court as directed by way of an affidavit next day. This matter again on second of September. Mr. Dole appears for response number 3 and 4. 3 and 4. Let it be on 2nd of September.
Okay. Let me.
I just wanted to probe 2 facts before Lordship. I'm appearing item number 41, my Lordship. Similar case, my Lordship. The Lordship
You
just
wait for the minute to hold up. Where is 41? Huh?
already called, my Lordship. It's connected, my Lordship. Lordship.
41 paper. Yes,
Your Lordship just now asked it for
the lordship just pose the question that either they have appeared for the 6-month period or not. So, my lordship, what happened in this case? I think I might not able to understand my learned friend. What if in my lordship in this case? Generally, my lordship, there are third BSMS and the fourth BSMS. So 6-month gap period is there, my lordship. So in this case, what happened, my lordship? Entire period of 5 months, 15 days was happened, my lordship. It is not 6 months completed, and exam was conducted by the controller, my lordship.
So let this information come.
My lordship.
That is what we directed.
Section 11 petition, my lord.
IA? From IA.
There was an IA, my lord, for substituted service, since, my lord, the respondents have then appeared on the last occasion.
Objections filed.
Yes. They sought time in April 2026, my lord.
You want to file or you don't want to file? Huh?
Fine.
File it within 2 weeks.
Contact the.
That is no ground. We'll give you 2 weeks. Forget it. Otherwise, we are passing orders. Give them 2 weeks for the time. Still,
As a last opportunity.
we'll do that. Still, the Chaudhary respondent. Time, last opportunity to file their objection. File, pass order. Again, after 2 weeks, 7th September.
Last occasion, your lordship directed, my lord, by order dated 10/8/2026. Director secondary division directed to personally appearance before this personally appear before your lordship. Today.
On last occasion, my lord, honorable directed to place the communication for a hearing was scheduled on 13/8/2026, and for what reason this hearing is conducted? This is my.
No, para 8, my lord, your lordship. Accordingly, let this matter be listed so and so by which the director will apprise the court, failing of which the court will issue consequences.
Reference to the earlier order dated so and so, whereby the director was required to apprise the court.
Yes.
As to circumstances on which the hearing was sought to be conducted with the petitioner and the inspector during the currency of the present proceeding. The director has submitted the reasons to the senior standing counsel, which are placed within the court. Let's peruse these reasons. And there any affidavit file? No.
No, my lord. We are preparing the
Considering the explanation given, the court does not wish to proceed any further. respect of the explanation sought for from the director. So the respondent state, including the director, are permitted 3 weeks' time file the detailed affidavit in respect of the claims raised by the writ petition. View this 100%. Still, immediately after 3 weeks on a date to be fixed by the registry. Liberty is also granted to the petitioner to file the reply affidavit in the event the affidavit is permitted by the respondents or file within the next returnable date. We've given a date to be fixed by the registry after 3 weeks. They will fix it. Okay.
Interestingly, that order which I was relying on, that went to appeal that I had shown, then it went to contempt. And then that particular case, they are complying in it.
I have some instruction that we are filing an appeal against the offset order also. But in the meantime, since there is no stay order as of now, so we are complying with this order now. There is some accommodation to be granted because the Arba Pujari is not
complying with which order?
Lordship, an additional affidavit is similar situated person. That's
similarly situated.
WPC 7131. Similar situated person. Similar situated person. Rupjiti Das.
Yes.
Which day went an appeal on an, and the ground of delay, the appeal was disputed.
That's okay. Now, here what is there?
And now, my lord, that since it is at finality, my lord,
You are saying that your matter is similarly situated as
forward,
Rupjiti.
yes, my lord.
Where is that order?
My lordship will find my affidavit. I have filed an affidavit, my lord. Lordship will find that at page number 68.
Hey,
68, my lord. Annexure 3.
part of
I had
the
filed an
affidavit
affidavit.
in opposition.
Yes, ma'am. No, no, ma'am. I had filed an affidavit. Additional affidavit, ma'am, by the petitioner. Last opinion was there.
Yes.
Well, it's got it, ma'am. 68. Page 68.
What is your prayer here?
Well, I had two folds there. One was regulation, which I abandoned now, madam. Now I'm asking for fixed pay.
In terms of Upendas,
Yes, ma'am.
that is set aside.
Madam.
Upendas is set aside by the FX board.
Yes. No, no,
How
my
can
lord.
it be implemented?
It's not. Implication is, my lord, something different, my lord. Upendas had been set aside, but my lord, but I remain lingering on my lord, petition of 2012, and based on Upendas.
Maybe, but today, how can there be a direction to implement the findings of Upendas?
My lord, leaving aside Upendas also, I am entitled to, my lord's, the minimum fixed payment.
Your minimum fixed pay was the direction was in Upendas only.
My lord.
Is there any other rule that provides for minimum fixed pay?
No, no, I have been working. Well, that's the reason. That was the reason I was harping on that order, man. Similar situated person.
Similar situated was at the time when Upendas was
Was there, my lord.
Now it is set aside.
Now, my lord, since then Dharam Singh comes to place because I am not
Then
traveling.
your claim will be for regularization.
My lord. Regulation pay is already there, my lord.
But you said you are not pressing it.
My instructions for my client were very clear. That's the reason. If lordship insists that, then I can pray.
No, I'm not insisting. Who am I to insist?
Well, yeah, I understand, man. Then I can pray, my
You
lord.
are before the court.
Because
Tell
today
us what
morning
you
that
can do.
very series that item 232, my lord. It discussed every law. And in
That is okay, but primarily it is relying upon vendors.
my lord,
Vendors will set aside.
set aside. Understand.
When we set aside, how do we now back and say that no, your case was the currency of that thing has to be.
I understand, my lord. I'm surfaced with very kind of different kind of challenge because, my lord, in the meantime, while this case was going on, similar situation, similarly situated persons were allowed. That went for contempt also. Now they are complying with also. With it also. Only I was left behind.
What to do now?
That case, my lord, I have to, without relying on that order, my lord, I have to argue afresh with Dharam Singh and Jaggu and that's all. That order.
Whatever you feel like.
Then, my lord can list this on next week, my lord, so the other angles can be, my lord, explored. Otherwise, my lord, I'm into service from 2008.
Say how you want to address the court.
My lord, next week, my lord.
On the request of the council of the petition.
All right. Yeah.
Maybe. So it's regarding selection to the post of lecturer, chemistry, Basugam. I take your lordship straight to the advertisement.
What happened? You were not selected.
Not Lord, my position is number 2.
What happened to
respondent-
number 1?
Respondent number 7.
So why are you challenging it?
Lord, regarding that teaching experience mark.
Teaching experience.
Lord, the advertisement is at page 30.
30.
30.
Yes.
Sold 29.
Yes.
The middle portion. Unreserved post. Terms and condition 1. Educational qualification and the selection procedure will be as per government office memorandum number so and so dated 24/1/2022. The last 6-7 lines mirror. The application must reach the undersigned within 15 days from the date of publication of this advertisement. Complete defective application will be summarily rejected. An interview call letter to eligible candidates will be communicated.
We'll carry it on some other day. We'll have to rise. Stay again for 1 week. Anybody?
Okay.
The respondent manual,
43.
43 man.
We are calling up because this is a digitized matter. We are going for paperless courts starting from today.
There is no available man. Taken up from that
43 petitioner available matter stands different to be listed after. Mr. Sheikh Mukhtar appears
for respondent.
for respondent.
Right.
Yes.
File rejoinder.
Petitioner counsel submits that you would like to file rejoinder after 1 week. Prayer made is allowed. relist this matter after 1 week. Mr. Rezbora appears to be responding. Yes.
Start the scan copy also.
Well, I will allow this, because I don't know who said either, because there's an arbitration clause which calls for appointment of arbiter in case of dispute. If they want to invoke arbitration, they can do it.
This is item number
45.
5.
Speaks for instructions. What kind of instruction they will give, whether they want to go for arbitration or not.
You're not filing an objection.
No, I know, it's because admittedly in the work agreement, there was a provision for arbitration.
Where is the agreement? Agreement. Okay.
So we have not annexed the agreement.
Okay, how you file on section 11 petition without annexing the agreement? Where is the clause? Third counsel to the party. Mr.
Zaman.
Zaman, counsel to the petitioner, we shall file an additional affidavit to bring on record the agreement executed by and between the petitioner, where he claims there is an arbitration clause which he seeks to invoke by filing present petition. We should actually dismiss this petition. There is no basis for filing it. How will you file this petition without the clause being there? That's a basic list after 1 week.
If you I quickly authorization, 40 pages made up for 1 minute, the matter was called. I am for the petitioner.
We have given some date.
It was listed after 2 weeks. My appearance may be noted.
All right.
Be clear. Like,